Lordship, prayer for adjournment for the day, item number 41, Lordship. Lordship, my senior is out of station due to some personal inconveniences.
May I pray, Your Lordship? Your Lordship, I am the petitioner side, Your Lordship. The matter is very much urgent, Your Lordship, because the accused, Your Lordship, is in the jail for last 10 months. Now, Your Lordship, he's dying in the jail. Some iron rod has been fixed in his right leg, Your Lordship. Some operation was operated in the year 2018, Your Lordship. And some iron rod has been fixed in his right leg, Your Lordship. Now, maybe due to some complications in that plate or iron rod, Your Lordship, he's shouting there, Lordship, dying. Otherwise, Your Lordship, on the other hand, the wife of the accused, Your Lordship, also lost her right eyesight, Your Lordship. So matter was very much urgent. So even
Lordship, my senior is not available today, Lordship.
Your
Lordship,
senior counsel is?
Firoz Khan, Lordship. Yes. I'm from informant, Lordship. He has prepared the matter. Last time also he was present. Lordship,
Lordship.
kindly one short date may be fixed, Lordship.
Lordship, can it be tomorrow, Your Lordship?
No.
Considering the
Not at all. Okay, cool. Your senior will be available in which
Yes,
day?
Lordship. Lordship, apart from today, any date, Lordship.
Otherwise, he is available. Your December
what is the, Lordship, can
after
you
1 week then.
Lordship, a date may be kindly a date may be fixed, Your Lordship. A date, yeah. 5th of can it be
Yeah,
5th? Your
everyone is
Lordship?
asking for date, then there will be no worry. Thursday, next Thursday. 5th, many matters are being fixed. Actually, if it is listed on next week, also next week, like they almost full. It may not reach. That is what people know. On 10, we can try 10, 12.
Lordship.
Otherwise, list is over. I was almost full. 10, 12.
Obliged, Lordship.
Not legal, Lordship. Regarding item 26, Lordship, I have inquired, Lordship, case there is not there.
26.
No.
Yes, Borba case day is not available. Your petitioner is an interim?
No.
Not interim. Issue reminder.
You can fix it around 13, 13.
Much obliged, Your Lordship. Much obliged.
My lord, I beg to mention item number 24, my lord. As per instruction of my court, I may be allowed to withdraw this my lord petition. Ma'am. Item 24.
When he got arrested or
No, he does not want to press the petition here. Also.
as per instruction of the client. What was your good name?
Hassan.
A. Hassan.
Obliged.
Okay, it will be disposed on withdrawal.
Obliged.
May please, my lord, item number 32. My lord, my daughter is suffering from illness, my lord. I have important for return my home early as possible, my lord. So kindly, my lord, item number 32. Matter may be taken at 11 a.m. my lord.
11 to possible, no, not possible.
So, my lord, 11.
Otherwise, he may be fixed.
No, my lord. So matter may be take a 12 noon, my lord.
That we cannot say that motion matters are there. You cannot fix that too. I mean 12.
So,
If it reaches, then it's good only
no,
because motion matters are there.
after
Your
motion.
daughter, if your daughter is ill, then
Daughter, she is
you
minor,
go.
my lord. She
Huh?
is minor.
You
No,
can
nobody
leave.
look
We
after
will
her in
we'll
my
take up
home,
the
my
matter.
lord.
That's what I mean. Your take the adjournment today. We are
No,
fixing
matter,
it.
that matter may be urgent. He is suffering from.
On one hand, you are saying that your minor daughter is ill. On the other hand, you are saying that the case will be. That is not the. Let it come. It will reach when it will reach. We'll take it. taken up.
Kindly,
We'll take it up at when it reaches.
Yeah, my lord.
We'll take it up at when it reaches.
Almost similar prayer, Lordship. I have some another matter in argument, Lordship. So can it be at 2?
Which one?
34. Long argument in
Now these are order matters. We
So actually
cannot
it was-
say at
it
this
was
stage.
it was motion measure actually. So I at that period of time while during the process of argument, we forgot to give the impugn order also. That is actually wrongly came in the order column. It should have come in the motion column. So because I have filed the IA, so it came wrongly as an order. It should have been in the motion column.
Okay, we'll see to it. Later.
Obliged.
May I plead your lordship?
Mm.
Your lordship, I beg to mention item number 19, your lordship. Kindly the matter.
19.
Yes, sir. 19. The matter will be adjourned for today, Your Lordship.
You are for the petition?
Yes. Your Lordship, the matter maybe can be fixed at 6 or on 6.
No, after 1 week, list after 1.
Must have like this.
May I please, Your Lordship? So I beg to mention item number 11, Lordship. I've taken the consent, Lordship. Finally, the matter may be taken on after 3 weeks, Lordship. After 3 weeks, I am for the petitioner,
You are for the petition.
Lordship.
Have you taken consent of the other
Lordship,
side?
PN, Lordship.
With the consent of so and so, list after 3 weeks. Go on.
So there is an interim that may kindly be continued.
Interim was there.
Lordship,
Interim be continued till next date of listing.
highly obliged.
May I please to note, I beg to mention for admission of criminal petition
You want for a listing?
list.
Make a mention before the senior bench as court number 18. Court number 18, you make a mention there.
Another word. Mention for orders, Lordship. MSC.
Senior match for
Before senior bench, make a mention before senior bench, it may be listed according. It may be listed.
Item 1.
May I please, Your Lordship?
Yes.
For 183 BNS application, Lordship. The petitioner behind the bar, Lordship, is 2710, Lordship. Your Lordship, may kindly see FIPS
2710.
2710. Your Lordship, may kindly see page 13 of the FIR, Lordship. May I read the FIR, Lordship? Page number 13, Lordship. বিনীত নিবেদন এই যে আজি ইংৰাজী 16/10/2024 তাৰিখে ৰাতি 8 মান বজাত এক গোপন সূত্ৰৰ ভিত্তিত চকীৰ ভাৰপ্ৰাপ্ত আৰক্ষী বিষয়া মহোদয়ে জানিব পাৰে যে নগাঁও দিশৰ পৰা মৰিগাঁও দিশলৈ A02CC 4244 A02HC 8905 you also may kindly note the number of this vehicle losses আৰু A01RC 4230 this number should be also noted losses বাহন তিনিখনত সন্দেহজনক চুৰি গৰু কঢ়িয়াই লৈ আহিছে মতে জানিব পাৰি চকীৰ ভাৰপ্ৰাপ্ত মহোদয়ে লগে লগে মিকিভেটা থানাৰ ভাৰপ্ৰাপ্ত বিষয়া মহোদয়ক উক্ত ঘটনা বিষয়ে অৱগত কৰাৰ থানাৰ ভাৰপ্ৰাপ্ত বিষয়া মহোদয়ে বিহিত ব্যৱস্থা ল'বৰ বাবে আইচি মহোদয়ক নিৰ্দেশ দিয়াত চকীৰ আইচি মহোদয়ে মই লগতে ইউবিচি সোয়েনসো ফুকন আৰু সংগী ষ্টাফসহ জালুগুটিলৈ ৰাওনা হৈ যাওঁ আৰু জালুগুটি ঘাইপথত গাড়ীসমূহ তালাচী কৰি থকা সময়ত উপযুক্ত নম্বৰৰ 3খন বাহনত সন্দেহযুক্ত চুৰি গৰু দেখা পায় ৰখাবলৈ সংকেত দিয়াৰ আটাইকেইজন তীব্ৰ বেগেৰে পলাই যাবলৈ বিচৰা তাৰে A02CC 4244 নম্বৰ বাহনখন ৰখাবলৈ সক্ষম হওঁ আৰু বাকী দুখন বাহন পলাই তীব্ৰ বেগে গুচি যায় পিছত উক্ত গাড়ীখন তালাচী কৰাত গাড়ীখনত থকা 6টা গৰু উদ্ধাৰ কৰিবলৈ সক্ষম হওঁ গাড়ীৰ চালকজনক ফুটফুচ কৰি জানিব পৰা যায় যে তেওঁৰ নাম মোহাম্মদ ইয়াজুদ্দিন পিতা সোয়েনসো ৰেচিডেন্ট সোয়েনসো থানা সোয়েনসো বুলি জানিব পৰা যায় আৰু চালকজনক গাড়ীত কঢ়িয়াই অনা গৰু কেইটাৰ কাগজপত্ৰ বিচৰাত তেওঁ কোনো ধৰণৰ কাগজপত্ৰ দেখুৱাব নোৱাৰাত আইচি মহোদয়ে সাক্ষীৰ সন্মুখত গাড়ীখনত থকা গৰু আৰু গাড়ীখন জব্দ কৰি চালকৰ চকীলৈ লৈ অহা হয় প্ৰকাশ থাকে যে উক্ত বাহন কেইখনত আগে পিছেও সন্দেহজনকভাৱে গৰু চুৰি কাৰ্য কৰি আহিছে দিছ দ্য এফআইআৰ লছৰ লছৰ নাও কাইণ্ডলি সি দ্য পেজ নম্বৰ 17 অফ ফৰৱাৰ্ডিং ৰিপৰ্ট লছৰ page number 16 no, sorry page number 16 lawsuit the FIR loss in 2016-10-2024 lawsuit and the petitioner was arrested on 2710 lawsuit now you also may kindly see page 16 of the forwarding report lawsuit paragraph 3 lawsuit ground of arrest lawsuit here it mentioned that during investigation I along staff started nakasking at Jaluguti Bazar 27/10/2024. You also kindly note 27/10/2024 on seeing the police team 2 cattle loaded vehicle registered as so and so as if I also mentioned in this number lawsuits A01HC 8905 A01PC 1183 lawsuits the incident took place in 2016-10-2027 and he was arrested on 27 the ground of arrest you also may kindly see that the vehicle was fled away on 16 lawsuit and they have arrested on 27 then on the ground was they have mentioned that on 27 they have taken a nakasking and this vehicle was fled away lawsuit.
So there is a discrepancy.
Yes lawsuit.
Okay.
What happened in this case lawsuit the a story narrated in the affair lawsuit is nowhere connected to the present petitioner lawsuit. Nowhere connected to the present petitioner. They were randomly asked at some persons lawsuits, alleging that they are doing cattle smuggling business lawsuits. So the 32 days in custody lawsuit, so further custodial integration may not be required lawsuit. The discrepancy in the FIR and the forwarding report lawsuit. FIR loss in 1610 lawsuit and the forwarding report 27 and 27 in the paragraph number 3 ground of arrest, they have explained that on 27 they have taken the Nagasaki lawsuit. So 32 days in custody lawsuit, further custodial integration may not be required. And to attack section 13(1) lawsuit, one have to violate section lawsuits 4, 5, 6, 7, 8 lawsuit. And what provision he has violated lawsuit? It's not a specific lawsuit. To attack section 13(1) of the Assam Cattle Preservation lawsuit, one has to violate section 4, 5, 6, 7, 8 lawsuit. If a lawsuit, can you see the section Assam Cattle Preservation Act lawsuit? Can you say section 13 lawsuit? 13 of the Assam Cattle Preservation Act lawsuit. Penalties lawsuit. So whoever contravenes any of the previous provisions of whoever contravenes any of the provisions contained in this act under section 4, 5, 6, 7, and 8 shall be guilty of offense punishable with imprisonment from so and so. Section 13 lawsuit. And you also can see section 4. Section 4 says the prohibition of slaughter of cattle. Section 5, prohibition of slaughter of cattle without certificate from competent authority. And section 6, prohibition of slaughter of cattle in place or other than a slaughterhouse. Section 7, prohibition on transport of cattle. Though this section is attack lawsuit, you also may kindly see section 7, subsection 6, clause 2 lawsuit, clause 1 and 2. Clause 1 and 2 say lawsuits, section 7, subsection 6, clause 1 and 2 lawsuits. No permission shall be required for carrying cattle or to grazing field or for agricultural or animal husbandry purpose within the state. And 2 lawsuits, no person shall be required for carrying cattle to and from registered animal market for the purpose of sale and purchase of such cattle within the state lawsuit. And you also can see 8 lawsuits. Prohibition of sale of beef and beef product lawsuit. So which section attack in this present against person lawsuit? So 32 days in custody lawsuit, the further custodial integration may not be required lawsuit.
Yes.
My lord, my humble submission, my lord, my learned friend here, this honorable court, my lord. My lordship may kindly come to my lord, page number 16, my lord. You may kindly see, my lord, in the FIR, my lord, the vehicle name, vehicle registration number has been specifically mentioned, my lord. One vehicle apprehended, my lord, wherein 6 numbers of cattle were recovered. Other 2 vehicles, my lord, fled away, lordship. Then police, my lord, could not apprehend the other 2 vehicles. Now, my lordship may kindly come to page number 16, my lord. My lord, during investigation, I along with staff started Nakaseki at Jaluguti Bozar on 27/10, my lord.
Yes.
My lord, this is a different incident, my lord.
Why they have
On
not gotten
20
defined
27
lawsuit?
let me
Okay.
complete, my lord. My lord, on 27/10/2024, the police was on Nakaseki, my lord. Then these 2 vehicles, my lord. On seeing the police team, the 2 cattle loaded vehicle bearing registration number so and so fled away in high speed, my lord.
Then why
Then,
they
my
have
lord, then police said, let me complete. please.
okay, okay.
Then police seized the vehicle, my lord, but they could not recover the vehicle. They have arrested the person, my lord. Because in the last line, my lord, but the vehicle have concealed by them as somewhere taking the advantage of zigzag multiple road, my lord. So, my lord, he is trying to say that, my lord, the incident of 16/10, my lord, and they were arrested on 27/10. 27/10 incident is different, but the vehicle number is same, my lord. Because the vehicle involved in this incident has been already been, my lord, mentioned in the FIR dated to my lord, 16/10/2024, my lord. These are the same vehicle, my lord. Again, my
Lordship.
lord, this vehicle were trying to
Lordship.
stop, but they fled away, my lord.
Lordship,
So
these are
my humble submission, my lord, this is from Morigaon district, lordship. Lordship may fix it next Saturday, my lord, we'll put in the case there.
Lordship, my submission is that lawsuit. If there is a different incident lawsuit, why they have not registered a different case lawsuit? Why this the earlier case which are registered in 16 lawsuit? Why they have registered in 27 lawsuit on a 16 FIR lawsuit? It's a different time. They should have registered a different case lawsuit. Why they have not registered different case lawsuit? Every incident is a different lawsuit. Every circumstance is a different lawsuit. Why they have registered in 16, which was registered in the 16/10/2027 4 lawsuit?
Short date may be fixed, my lord. Next Thursday, my lord, I am bringing only 7
No,
days.
if
time,
also
my lord.
not
With
giving
producer
bail
case
lawsuit,
diary.
tomorrow lawsuit, the case is fixed in this court lawsuit, item number 35 lawsuit. Case diary is there before this honorable court
Then,
lawsuit.
but tomorrow, my lord. Then.
Tomorrow, another case.
Yes, so item number 35 lawsuit in AB number lawsuit.
Maybe number 2.
AB number lawsuit 3011 lawsuit. 3011 24 lawsuit.
Call for the case diary, list accordingly along with
AB.
AB.
AB 3011. Case diary is there lawsuit.
Case diary dear means.
On that day, lawsuit, the matter was listed lawsuit, not reached lawsuit, but on that day, lawsuit, the diary was there in the court lawsuit.
31
Let's 3011 lawsuit.
3011.
24 lawsuit.
Okay, listing it.
Lawsuit. I'm obliged lawsuit.
Item 2.
Maybe. Well, this offense under section POCSO, my lord. The NBW was issued, my lord, and accordingly the petitioner signed up before the court on 28/10, my lord. So let the matter, let the action copy make it call for, my lord, from the session, the special judge.
So since 28/10, he is in custody. Okay. Where from it has to come?
A special judge, POCSO, Bishnu.
It is charge sheeted one.
Charge sheeted and the case is pending special judge, POCSO. my lord.
Acha, acha. Yes,
Scan
when-
copy, my lord. Scan copy, my
scan copy definitely will call for the scan copy when it can be called for.
my lord. That will be called for through the registry, my lord.
Yes, yes. Now I'm just asking you the
My lord,
date, any date.
Let it be, my lord, the 3rd of December, my lord. Or in the
1/3,
Of my lord.
13/12. Scan copy of the answer, registry will take steps. Okay. Item 3. Yes.
May I please appoint? Lordship, in this case, impugn order at page 49. In this case, my lord, a complaint case was filed under NI Act against the petitioners. And my lord, petitioner number 2 is a NGO and petitioner number 1 is the secretary of that NGO, my lord. So the private respondent number 2 had invested in their ongoing projects of the NGO, some projects, governmental projects, for rupees 13 lakhs, my lord. Thereafter, an agreement was executed that this 13 lakhs will be refunded by the NGO to the private respondent number 2, along with some dividend, my lord, interest. So thereafter, my lord, all of a sudden, in the meantime, since the NGO was not getting the funds from the government, so all of a sudden, this private respondent number 2, my lord, with some Gunda Bahini, that is, my lord, entered to the office of the NGO and procured 2 checks of, my lord, 17 lakhs. One it is, my lord, 10 lakhs and another is 7 lakhs. In lieu of, my lord, 13 lakhs. He invested 13 lakhs.
So your condemnation petition was rejected.
Rejected.
Yeah,
On that
before
point.
going the matters, we have to hear.
My lord. And my lord, John specific in the, my lord, objection is very much clear, my lord. Because, my lord, he was aware of the order passed by the trial court, my lord. In spite of that, my lord, he has not placed all the materials, my lord, and he said he has stated some other facts, my lord, in the condemnation application. That is why it was rejected, my lord.
It was
So at least,
rejected.
my lord, only notice may be issued, my lord.
Yes, not.
No, my lord, in this case, my humble submission is that I have stated in grounds that my earlier engaged counsel was misleading me.
No, see,
And,
this is your appeal was not disposed on your merit. It was disposed on at the stage of, well, either not yet
that
admitted.
appeal
So
was
how
not
can you pass
admitted.
any order, stay and all? Now, in this case, it cannot be.
My lord, sentence is, my lord, still in prevalence. So that sentence, main sentence, it is, my lord, conviction. That-
Your,
Conviction cannot be stayed, my lord. At least.
how can we stay now? Your appeal is not in existence. It was not disposed on merit. it was not even admitted or entertained. So that is the reason.
Otherwise,
If this application is allowed, then he can prefer an appeal, my lord.
Yes.
my lord,
Then only you
otherwise-
can.
Otherwise, I am facing some problem.
No, you may face, I can
because
understand,
NBW
but the
has-
question is that we cannot now at this stage, how can we?
NBW has.
Stay
already
does not,
issued-
question of stay doesn't arise at all.
my lord,
Your
NBW
appeal is not get
I may be
admitted.
protected. NBW has already been.
The
protected-
petition is
issued.
disposed in here. In
My-
that case, only your appeal may be admitted in that, when that time somehow some kind of order may be passed, but at present, it's not possible.
My lord,
If you notice, go to
I have stated a specific ground that I was present at the court, my lord.
This
but
has to
the-
be heard, no?
but
then,
it
then
was
only
not-
we will come
It
to.
was not my given
Because
knowledge that I
as
have. been
Mr.
convicted.
Borwa has submitted that in your petition, there was no mention at all about anything.
But-
That is maybe the reason why your condonation was rejected.
I have admitted this fact, my
This
lord.
one. Oh.
But out of some compelling circumstances, my lord.
Hard so and so করে দিব, issue notice করে দিব খালি, হ্যাঁ? Issue notice to the respondent number 2, no formal notice is required so and so করে দিব. Also call for the LCR করে দিব. Your this was this criminal miss, na?
Criminal miss.
Miss 06/2024 arising out of criminal appeal number 18 of 2020.
Criminal miss case.
Learning session just to that, yeah.
My lord,
You
my,
take steps, we are listing it after 3 weeks.
my lord, my humble submission, I'm repeating this, pardoning it. My
No,
lord,
no, see, your appeal is not there. How can we pass your
No,
order?
my lord, my submission is that, that ground, whatever I have submitted before the.
Obviously, it will be-
was
it
not
will be
entertained.
After
So in
hearing
this-
on your petition, then it will be
Yes, in
decided.
this regard, I
Obviously.
have, my lord, one judgment.
No,
from
no,
the
judgment
Supreme
is all
Court,
right.
my lord.
Judgment is all right. 3 weeks after 3 weeks.
Obliged.
Item 4.
Criminal petition lordship challenging the order taking cognizance. Here also lordship has already passed an order yesterday in item number 12. The issue is similar. May I place the order? Here the cognizance has been taken without prosecution sanction. And the petitioner before lordship is a junior engineer. She was posted in West Karbi Anglong, Lotika Soikia.
This is another case for said Lotika
Yes, yes,
Soikia.
from the same area.
Then she is the,
Then, but earlier, mother, I have one submission, my lord. This order taking cognizance was passed on 16/5/2023, my lord. Now it is almost, mother, 1.5 years, my lord. So why did it come today, my lord?
No, because we were posted in some other place, so we did not receive the summons. The moment we received the summons, and then we approached this honorable court. The appearance is yet to be completed because there are 4 or 5 accused in Rashid.
no, cognizance was taken as he submitted it in 2023.
23.
And then you received your
Summons.
summons on? Lately.
I have stated in the paragraph. At paragraph 5, page number 11, lordship. Since we received the summons in that case, and then we came to know that this case is also cognizance has been taken, so we appeared voluntarily in that particular, here in this case. And there is no such bar in filing a petition for quashing,
No,
lordship.
there is no bar, my lord, but question is that, my lord, if the trial court has already proceeded, my lord. If the charge has been framed, my lord.
No, no,
Do
no,
not-
not at all. Charge has not been framed. Because the appearance is yet to be completed, lordship. And when the cognizance is bad in law, can the trial court frame charges, lordship? The issue is exactly similar. At page 52, your lordship will find serial number 15, page 52 of my petition. Serial number 15, whether prosecution sanction, if required, obtained or not, if yes, particulars thereof. So it is absolutely silent, nothing has been
No
mentioned.
section, my lord, can be obtained during the trial. There is no bar.
And regarding the order taking cognizance, in this order no way says that the prosecution sanction was taken. 197 says that no court can take cognizance without obtaining prosecution sanction in respect of public servant. Yeah, Lordship has already heard the matter yesterday at length and granted an interim order, Lordship. So I'm just praying for a similar order.
Date of FIR, FIR or date. Sorry, here the FIR is date.
Lordship, at page 38, the FIR was lodged on 9/9/2012. Charge sheet is filed on 23/9/2023 after 11 years.
2000.
FIR was
9/9.
filed on 9/9/2012. Seven 9/2012, Lordship. And charge sheet is filed on 29/3/2023. After 12 years, after 11 years. That too without obtaining prosecution sanction. They could have obtained the prosecution sanction in the meantime.
Same order. Okay, same order will be passed.
Lordship.
State.
Lordship.
Hard to read. Only the order to copy. After 4 years. You take steps on response number.
Lordship. All right, Lordship.
It will make deliver year without asking, you know.
May I please? The only matter, my objection may be recorded in my writing, not writing.
Yes, my lord, kindly fix the matter at 2 p.m., my lord. At 2 p.m.
Thank you. May it please your lordship. My lord, here we are challenging a domestic violence, my lord, application, my lord, filed by the wife. Now, before coming to that, my lord, lordship may kindly see, my lord, Annexure 1, that is page 10. My lord, way back in the year 2021, on similar allegations, my lord, maintenance petition has been filed by the now aggrieved, my lord, that is it, 2021. To 2021, lordship, then lordship may kindly turn to page 16. Page 16. My lord, that, my lord, they had an amicable settlement. Page 16 order, lordship has got it. My lord, no, then there was an amicable settlement. In the order itself, it reflects. Seen the petition filed jointly filed by the petitioner and the opposite party. They had settlement of 10,000 rupees. This 10,000 rupees in the maintenance case, I'm still paying up to date without any fault. Without that, I have categorically stated. Without any default, I'm paying that 10,000. And my lord, now she has again filed a domestic violence case against me, stating the same facts after the settlement. After the settlement, that is Annexure 3. Annexure 3, page 17. And here she has stated, she has herself stated in paragraph 4, page 20, that she has left my house at 2020. Now she is making that after the settlement of the maintenance proceeding, now again she is claiming some extra money from the petitioner. Page 20, she has admitted that she left my house at 20. Now this is the case, Mala. Now since 20, there was a settlement. We are paying regularly 10,000 rupees. 10,000 rupees. Now again a DV case. Here we have only received notice. So, may I pray, at this stage, Lordship may.
Along with the prayer for maintenance and all, what are the other prayers? There are some other prayers also, I think, because it is a DV.
DV,
what is the money relief is?
Residence orders is also there. Residence claim is also there. But it was settled earlier, 10,000 rupees, and this was filed Actually, she has stated she has left my house at 2020. Actually, she left at 2019. And after almost 5 years, this DB case has been filed. With an intention only to harass, because 10,000 rupees I'm regularly paying. That I have categorically stated in my petition. At paragraph. Paragraph 6, my lord. And here are the copies, paragraph, my lord, which I am regularly paying the 10,000 rupees. I'm regularly paying the 10,000 rupees without any default till date. So at this stage, my notice may issued, my lord, and proceedings of the DB case may be stayed, my lord. With the direction that I would regularly pay the maintenance amount of 10,000 rupees.
Heard Mr. S.M.P. Abdullah, the learned counsel for the petitioner, and also heard Mr. R.G. Burva, the learned additional PP, appearing on behalf of state respondent number 1.
That is only a formal party.
Formal
Yes,
party.
I know. But you have made party, that's why I made. And so, this is an application on section 528 BNSS for quashing or setting aside the proceeding of DB case number 109 of 2024, pending in the court of learned JMFC, Kamrup M, Guwahati. Issue notice on the respondent number 2, no formal notice is required to be served, so and so. Also, call for the scan copy of DLC. Mr. Abdullah further submitted that the earlier one maintenance case was lost by the respondent number 2, which was registered at FC criminal number 56 of 2021, and said case matter was also settled amicably and by order dated 24/2/2023, the learned Principal Judge Family Court number 3 Kamrup M had directed to pay the maintenance to the respondent number 2 at the rate of 10,000 for the petitioner and for her 10,000 for the respondent number 2 and her minor child. Since the date of order, the petitioner is paying the monthly maintenance at the rate of 10,000 per month till date. But subsequently, after settlement of the above referred criminal FC criminal case number, FC criminal case, the present DB case has been lost by the respondent with the same allegation made in the earlier case. We further submitted that the petitioner is still paying paying 10,000 towards maintenance of the first for the respondent and her child regularly before the court till today, and accordingly paid for stay of the further proceeding of the DB Act till disposal of the so-and-so. Considering the so-and-so corridor till next date of listing.
Till next date is stayed, ma'am. Oblige your lordship.
Item 7.
May I please, Your
Yes.
If this petitioner has challenged lordship in this petition, the succeed, lordship, whereby lordship, the investigating officer has succeeded the FIR lodged by the informant under section 376 and 448 and 511 and 506. I think at this stage, lordship, I am praying only for notice, lordship, because the record I have not annexed with the petition.
Scan copy may be called for.
Yes, lordship, that may be called.
One Mr. J. Kolita, so and so. This is an application quotable, issue notice, also call for the scan copy of the LCR from so and so. You take steps, we are calling for the LCR.
Lots.
After 4 weeks, we are listing.
Yes, Lordship, one line may be observed, Lordship, regarding the stay of this proceeding, Lordship, after receiving the LCR, Lordship will.
After receiving the LCR, the prayer on stay may be considered.
Lord, yeah.
Can you the LCR?
Yes, yes, can.
Scan copy of the LCR. Obliged.
Item 8.
May it please your lordship. Lordship, the petitioner herein has paid for Jimma of a custody of a vehicle, lordship, on 11/9/2024. That was rejected on mere technicalities, lordship.
Where is the order?
Is at page, lordship, 24. Lordship. Report has been called from the IO as well as DTO, lordship. It has confirmed that the vehicle is my vehicle, lord.
Vehicle is?
Vehicle is my vehicle, lord. There is no dispute as regarding to the ownership of the vehicle, lord. But that has been rejected only on the technicalities, lordship.
From where you are saying that the ownership is not disputed? Is there?
Lordship, ownership, lordship, they have DTO.
No, you are claiming that you are the owner. Where
Yes.
is there any reflection in the order that the ownership is not disputed?
It is not reflected, but lordship, DTO report I have annexed in annexure 5, lordship.
Annexure 5.
Annexure 5, lordship. This is the verification, lordship. Okay. Then if there is any confiscation proceedings also drawn against a vehicle, that has also been clarified in annexure 6. By the deputy commissioner that no confiscation proceedings has been drawn.
You obtained this by applying or was there?
It was called for, we have applied. Lordship, here we have we are called for, because SOCOS has been given to me, lordship. Lordship, para, lordship. 3 para, lordship, in annexure 6, lordship, whereas the written reply submitted by Sri Krishna Fukan, constituted power of attorney holder, vehicle number dismissed, was found satisfactory after verification of all relevant documents, which we were attached to with which were attached with the SOCOS reply, lordship.
In last para, what is it mentioned that hereby order to confiscate for confiscation of seized 298 numbers of 14 kg
These
cylinders?
are cylinders, lordship, carried by the vehicle, lordship.
No, yes, that is already confiscation order was there only.
That was proceeded with, lordship.
But for vehicle, you are not saying that for vehicle is not there.
Yes, lordship.
Yes, Musa.
My lord, petition was rejected by the, my lord, Dhanet trial court, my lord. My lord, in view of the order passed by this, the previous bench of this honorable court, my lord. That is, my lord, page number 24, my lord. Lordship may kindly come to page number 24, my lord. Second paragraph. It is found that the Honorable Guwahati High Court in criminal number 284 of 2022 while referring to decision of Honorable Supreme Court held that under section 457 CRPC, which deals with procedure on seizure of property, court can exercise power if the seized property is not produced during investigation. In this case, it is found that prayer for Zimma is made for the seized vehicle, which has been produced before this Honorable Court, before this court. So, my lord, this Zimma application was rejected by it.
What's if that has been rejected on mere technical things? What's if mere wrong quotation
Not mere
quotation of?
technically, my lord, in view of the order passed by the division bench.
What's if there are several judgments of the Supreme Court as well as Honorable Guwahati High Court that says that mere wrong quoting of the section will not be fatal to the grievances of the petitioner.
No. As per submission made by the by Mr. Borwa is a bit different because you are saying there's merely technical issues that was rejected, and the order speaks that as per the decision referring to the Honorable Supreme Court only, where it was just was the decision that if the articles could not be produced in that case, the seizure order of this Jimma could have been passed. And this kind of thing is, but the order is, I mean, admitting that order is not so clear or not so reasonable. Anyway, but at this stage, we are not in a position to say whether there is any confiscation proceeding because confiscation of the cylinder process is already there. From the report we have submitted NSL 6.
That cylinders are also mine because the petitioner, lordship, I have annexed a document, lordship.
Now, if it is cylinders, also if it is your cylinder, but the confiscation has already been initiated.
That has been initiated, but
that's why we just call for
because regarding the lordship, last way, lordship, the Jimmy will come 7 days from the receiver. As regards to the seized vehicle, the police will take necessary steps for consideration of the prayer of the petitioner to release of the seized vehicle. Lordship.
Thereafter, have you approached the authority concerned? Why didn't you approach?
Lordship, 3rd September, this was order of 3rd September. Lordship.
Yes, obviously.
And it was
thereafter whether you have approached, because it is one line is last line, as you have mentioned, that as regards to the seized vehicle, the police will take necessary steps for consideration of prayer of release of the vehicle.
That prayer, lordship, we have put before because put before the.
Okay, we are calling for the report at this stage.
Yes, my lord, report.
If it is not confiscation proceeding, obviously, if you dispute is not there, because cylinders are already been confiscated. Now, see, we'll go for the case record. It is an criminal petition করে দিব under 20 বাকি লিখিব so and so call for the police report করে দিব report from the IM in regards to the seized vehicle. Your vehicle number is
not AS01 RC, lordship, 2483.
Just a second. AS01
RC 2483.
2483. So and so seized, alleged to have been seized in connection with this case. List after 2 weeks.
Date may be fixed because the vehicle is lying.
Fixed date. Prior to vacation, there is no date at all, in fact.
Because the vehicle is lying in open and EMI.
So we build it beside like an date, but it's not possible for us for everyone to give a date. In fact, otherwise.
In this kind of case, fixed.
2 weeks website by data sending. 16, 17, 16, 15. These are opening day. 16, 16, 12.
Alright.
Item 9.
Please, lordship. My lord, we have come for against issuing warrant of arrest against me, my lord, for remaining absent only for 1 day. Lordship may kindly say FIR page 10.
No, FIR, let you forget about the FIR.
Yes.
Where is the,
Now,
where is
lordship
the
may
order?
kindly say the impugned order that may page 20.
20.
Yes, 20.
Your name is?
My name is Ghulam Hussain.
Ghulam Hussain.
29/5/20 accused is present, IO is absent. Issue summons to IO through SP Morigao. Then 13/6, my lord, accused Ghulam Hussain is present, IO is absent. Then Lordship may kindly see 10/9/24. Accused Ghulam Hussain is absent without taking any step, issue NBWA against the accused. So now I am afraid that if I appear, I will be sent to custody because NBWA is there. And my submission was that the
Now see, I am also from the law judiciary. What is the process? If suppose the case is at the stage of evidence or suppose at the tempering of charge, then in considering the absence of the accused without step, you have to issue notice. I mean NBWA. But if you appear before the learned trial court below,
I will appear and
no, before filing this one, you could have appeared before the learned trial court below, in fact.
But I have
One day generally considers, generally the court considers.
but I went there and somebody told that it is not possible, minority will be sent to custody. So my lord, this order may be quashed and I will appear. Next date of the case is fixed on 20th January. 20th, yes. 201/25.
He absent without any steps.
Yes, that's why the NBW was issued.
Maybe I leave it here also.
Pardon, Mr. Ahmed. Item number 9. Mahmood, the learned counsel for the petitioner, and also heard Mr. R.J. Borwa, the learned additional PP, appearing on behalf of state respondent. This is an application under section 528 BNSS.
Section 5 to 8.
Against the order dated
10/9/24.
10/9/2024 passed by the learned.
In between one that has gone and 18th anniversary has gone.
10/9/2024 by passed by learned CGM Kamrup M, whereby the learned trial court had issued NBWA against the present petitioner in connection with GR case number 10735 of 2015 under section 279/304A IPC. IPC full stop. It is submitted by Mr. Mahmood that that he was regularly appearing before the learned trial court below on each and every date, and at the stage of each and every date so and so, and on 7/3/2024, 3/13/6/2024, the case was fixed for evidence of IO, recording of evidence of IO. And in those dates, the accused petitioner was also present before the court. But on 10/9/2024, he could not appear before the learned trial court below. Why he could not appear? Is there any reason?
Actually, he said that I have a telephonic talk with the lawyer. I asked the lawyer to file a petition and he also sent it, but the lawyer did not file any petition.
Could not appear due to some personal inconvenience, and his engaged counsel did not take steps on his behalf, for which the learned trial court below had issued NBWA against him on 10/9/2024 and on subsequent date, that is on 18/11/2024. The next para, Mr. Mahmood further submitted that accused is regularly present appearing before the learned trial court below and was contesting the case. However, on 10/9/2024 only, he could not appear before the learned trial court below, and considering his absence without stay, the NBW was issued. However, he is ready and willing to appear before the learned trial court below and to contest the case if he is allowed to, if he is if he can if he can appear before the learned trial, if some kind of interpretation is given till his appearance before the learned trial court below. Stop. Next para, Mr. Borba, the learned judicial PP submitted in this regard, that direction may be given to the present petitioner to appear before the learned trial court below with an appropriate application for bail. Next para. Hearing this submission made by the learned counsel for both sides, considering all aspects of the case and also considering the fact that NBW was issued against him only for only for his absence on 10/9/2024, comma, this court is of opinion that the petitioner may be allowed to, no, maybe, no, not like so and so. This court of opinion, like so and so, allowed 10 and so and so, the command, the petitioner is hereby directed to appear before the learned trial court below with an appropriate application for bail, which shall be considered by in accordance with law. However, till his appearance, next date is 2005, no?
Yes.
2001.
21/25.
However, till the next date that is on next date fixed, that is on 20/01/2025, he may be protected, and the NBWA issued against him may be stayed or be suspended. With the above observation, it stands disposed of at the motion stage itself.
My lord, one small prayer that if I file petition, then that may be considered as per the observations made by this alone.
According
Not
to
required, my lord, because his lordship has already, my lord, stated him on NBW.
everything is there only,
Obliged.
Item 10.
disposed of.
May I please, your lordship, 482 application, your lordship. The FIR is at page 15, your lordship. This is.
FIR is at page 15.
Yes, your lordship, it's a translated copy, your lordship. Your lordship, the FIR was lodged on 8 September 2024, and the alleged offense was committed on 1/9/2024, your lordship, after the lapse of almost 1 week, your lordship. And the actual point for which the FIR was lodged, that is narrated at paragraph number 4, 5, and 6 of my petition, your lordship. Actually, there was a land-related dispute, your lordship, and arising out of that land-related dispute, your lordship, argument took place between the petitioner and the informant, your lordship, and as a result of that, the FIR was lodged, your lordship. But the FIR is registered under POCSO as well as the other offenses of DNS, your lordship. That is the reason that this your lordship, notice may be issued and case diary may be called for, your lordship.
You made respondent number 2 is the informant.
Yes, your lordship.
Into corrigible, hard corrigible. You are Mr.
I.H.
Laskar, I.H. Laskar, so and so, and also heard Mr. R.J. Borwa, so and so. This is an application under section 482 of BNSS, Bakil Khidiba, so and so. Issue notice to the respondent number 2, OC of the concerned police station, OC of the jurisdiction police station, true, routed to the office of the public prosecutor and the registry. Also call for the case diary and list accordingly. Yes, when it can be
16/12.
16. Listing 16.
43 of the supplementary list.
Yes, please, your lordship.
Yes.
This is a 528 application with seeking quashing of a complaint case, my lord, including the order of cognizance. So the petitioner before your lordship and the respondent number 2, my lord, they are cousins, and they have been feuding over ancestral property for considerable amount of time, my lord. Now, in this regard, my lord, will kindly see page 15. I don't have page 15 now.
Yes.
Page 15 is the title suit, my lord, which has been filed by the petitioners and their family members against the respondent number 2 and his family members, my lord. Seeking the specific prayer is, my lord,
plaintiffs are the petitioners
and their family members, my lord. And the defendants are the respondent number 2, my lord, and his sister, my lord. So they are seeking declaration of right, title, and interest over the suit land and for recovery of possession. So this land is under the possession of the defendant. Now, my lord, in this regard, the defendants have also appeared and they have filed their WS. My lord will find their WS at page 27. So while this civil dispute is purely civil in nature, the respondent number 2 goes and files a complaint case before the court of the learned CJM Shankardev Nagar. Madam. The primary allegation is that the petitioners had entered into their land, abused them, pushed them, and shoved them on the ground and threatened them. Now, my lord will kindly see the initial deposition of the respondent number 2 at page 39. This civil dispute is also disclosed there, madam. Page 39. May I read, madam? I filed this case against my Moimun Nessa, Asaf Ali, Isof Ali, Soyer Ali, Rusna Begum, Sultan Nessa, and Yunus Ali. 204 Nong Miyadi Patta land bearing dark number 304 at Beloguri, Pathar Kisamatar was in the name of my mother. Koirun Nessa accused Moimun Nessa by deceitful means registered a land in her name. On knowing the same, I informed the same to the Mondol, who assured me to settle the matter. On 24/10/2023 at about 10 AM, all the accused persons came to my house and started to abuse me verbally. Moimun Nessa pushed me and I fell on the ground. Someone kicked from the backside. After the incident, I went to the PS. The OC of Doboka PS suggested to file a complaint case before the court. So this is the allegation which has been leveled against us, my lord. They mention about verbal abuse. They do not mention any obscene use of any obscene words. Still, cognizance is taken under 294. No mention about any injury sustained, my lord. Still 323 cognizance is taken, my lord. No mention about any threat, my lord. Yet cognizance under section 506 is taken. And this being an ancestral property, my lord, they are already disputing. It is also admitted position. The civil suit is also pending, my lord. This question of trespass will also not arise, my lord. Cognizance order, my lord, will find at page 48. No, 447, 294, 323, 506, and 34, my lord. Even if their allegations as alleged in the initial deposition are taken into consideration, my lord, these offences are prima facie not attracted. Otherwise, also, my lord, dispute, there is an existing civil dispute between them. Competent civil court is deciding this, my lord. This complaint case has only been filed to harass the petitioners, my lord. So this case is covered by, my lord, both of the parameters of Bhajan Lal, my lord. When a case is filed only to harass a petitioner, my lord, and when prima facie ingredients are not attracted, my lord. So I'm saying that this says notice may go, my lord, until returnable date, my lord. State, my lord.
So may kindly come to, my lord, page number 37, my lord. What is the real fact of the case? Page number 37, my lord. This is the vernacular of the complaint petition, my lord. I'm reading from 36, my lord. Koyadi Binit Division is the Jomunamuk Mozar Ontoguto Veluguri Potar, this motor is Isamotor, Duko Sarinam, Miati Patra, Chinico Sarinam Dagor, Koyadi Kokai, Omirali Namotoka Mati, their Mitu because the Utuatiki Hopole, Telpon Namat Namjari Korailo. Into Uktua Namjari, Ekno Asami, Uti Soturali would Dal Sozi Kori. তেওঁৰ নাম অমিৰ আলী উত্তৰাধিকাৰী সকলৰ লগত সামিল কৰি অমিৰ আলী উত্তৰাধিকাৰী হিচাপে নামজাৰি কৰে প্ৰকৃততে 1 নম্বৰ আসামীৰ দেউতাকৰ নাম চিন্তা জানিমা This is the real fact for which the complaint has been filed.
No, my lord, the complaint cognizance has not been taken in respect of this civil dispute, not regarding forgery, not regarding any of this. Cognizance has been taken in respect of criminal trespass 294/506, my lord, whether those offences are attracted. And my learned friend has read out for the side of their complaints. My lord will kindly see the title suit which we have filed. Here we have very categorically stated, my lord, regarding all of these things, my lord. How this has come about, my lord. This land originally with page 19, my lord. That is anyway not the subject matter of the complaint case, my lord, but I'm still pointing out, my lord. This land originally belonged to one Kartik Satnami, my lord. Kartik Satnami sells the land to Muqaddas Ali. Now, Muqaddas Ali in turn sells the land to Khairun Nessa. Khairun Nessa is the... Now, Khairun Nessa dies, my lord. And when Khairun Nessa dies, she was issueless. Her husband had another wife, my lord, Fatima Khatun. Now, these defendants were the daughters of children of Fatima Khatun. They projected themselves to be the children of Khairun Nessa. The land belonged to Khairun Nessa. Husband had two wives, Khairun Nessa and Fatima. These are the children of Fatima. but they projected themselves to be the children of Khairun Nessa and got the land mutated in their name. So this is an aspect which is under consideration before the competent civil court will decide their respective rights, my lord. Who is in the right, who is in the wrong. The case which has been filed against us is regarding whether we had trespassed, whether we had abused and threatened, all of those things. That is not made up from their initial deposition, my lord. So at this stage, my lord, that is my humble submission, my lord. Let the proceedings be taken.
Let the opposite party appear, my lord.
Because we have given every document, my lord, regarding the complaint case.
Heard Mr. S. Nawaz, the learned counsel for the petition. And also heard Mr. R. J. Borwa, the learned petitioner, BP, appearing on behalf of state respondent. This is an application assistance so and so for washing of depositing so and so. Issue notice to the respondent. How many respondents?
One respondent, respondent number 2, my lord.
Respondent number 2 through registered AD and as usual process. No formal notice is required to be served on respondent number 1. However, extra requisite copy may be served during the course of the day. Mr. Nawaz, the learned counsel for the petitioner, submitted in this regard that the actual dispute between the parties and the land dispute is going on between the parties. And in that regard, the petitioner and the other family members have already lodged a title suit against the respondent and the family members, which is still pending for disposal. They have also, the respondent side also filed a written objection, written statement in the said case. However, during the pendency of the said civil suit, the complaint was lodged against the
complaint was not lodged during pendency. Complaint was lodged first and then civil suit. Cognizance was taken during the pendency of the civil suit.
Oh, complaint was earlier.
Complaint was, I'll give the dates, my lord. Because there was also another proceeding pending before the circle officer, my lord. I'm giving the list of dates, my lord. Complaint filed on 27/10. Civil suit filed on 22/11. Initial deposition recorded on 11/1. So complaint on 27/10, title suit on 22/11, and initial deposition on 11/1, cognizance on 22. Cognizance was taken.
Submitted that one complaint was lost. The present complaint was lost by the so and so the respondent on 27/10/2024.
23.
So sorry, 23. And after lodging of the complaint, another title suit was lodged by the petitioner and his family members. তাতে আপনার WSDC মই আগতে লিখিলো তাত লিখি দিলো but during the pendency of the title suit the cognizance was taken. The initial deposition was recorded on 11/1/2024 and the cognizance was accordingly taken by the learned trial court below on when
22/24
22/11
22/2/24
22/02/2024. But on mere perusal of the complaint as well as the statement recorded under section 200 CRPC, it reveals that the no case is established against the present petitioners under section 447-294-323-506 by 34 IPC. But without having any materials, the cognizance was taken against the present petitioners. Accordingly, Mr. Nawaz submitted that the prayer paid for stay of the proceeding in connection with stay of the proceeding of CR case number 819 of 2023, pending before the court of learned JMFC Hosai, Sonkodev, Nagar. Next para, Mr. Borwa, the learned citizen PP, submitted in this regard that in the complaint, they not only brought the allegation of assault and abusing with filthy languages, but there are other allegations of forging of the signature of the respondent and respondent in the complaint petition. Accordingly, he submitted that only notice may be issued to the respondent at this stage. Next para. Considering the submission made by learning consistent so, common materials in the case record and other aspects of the case, further proceedings take away till next date of listing.
When forging of signature is not there, that is soturali kori, jal saji kori. So perhaps.
Surely Jalsaji মানে কি?
Jal Saji Malov, Jal itself is a forgery, my lord.
Signature is.
No, my humble submission is that, my lord, for this incident, my lord, they have lodged an application before the circular officer for cancellation of the mutation, my lord. Then this incident took place, my lord.
The only thing was
Because these are related, my lord.
signature part may not be mentioned because that is not there in the statement.
No, no, take a question Jalsaji kori.
Jal saji, jal sohi is not there. Jal saji.
Jal
I mean,
Saji, my lord,
anyway, my lord, if that is a submission, let it be.
By fraudulently.
Fraudulent, yes, my lord.
Fraudulent,
Fraudulent.
Non signature no koribo. Fraudulently.
Fraudulently mutated.
Oh, like tips are miladi.
Deeply obligated.
Four weeks. Food. The part her too.
Lordship, I will take your lordship to the FIR, page 14. The operative portion, lordship will find it. He is coming. Lordship will find it page 16. The FIR.
Page 16.
Page 16.
Hello, we are taking up the matter of this 22. Bail application 2989.
Lordship,
It is a
2989.
stage of bail hearing, in fact.
I didn't get lordship.
We are taking up the matters of bail application 2989.
Yeah.
It is in bail hearing column. Whether any CD etc. has to come or just one.
Not yet received the same CD lordship in this case. Right now, it's not received, but it is coming lordship.
Coming.
Might be under take instruction lordship.
Oh.
Today, we are behind the bar for 81 days, lordship.
No, that's what he did. CD is coming, he is saying. Maybe a bit
Pass over for time being lordship.
time being.
Time being lordship. Let me take instruction whether they are coming.
Pass over just for time. Otherwise, he is in custody for 81
days. On the ground of detention, long detention, lordship, you can consider the case.
Okay,
And
we are
so-
keeping it in timely. Let him take the instructions first.
I'll leave it.
23.
May I please your lordship? Lordship, as per order dated 24/10/24. 24/10/24.
4/10/24. 24/10/24.
The petitioner has appeared before in the police station, and the kettles have been handed over to the petitioner.
Huh?
The kettles has been handed over to the petitioner.
Who handed over? Who handed over?
17 number of bull.
Huh?
By the police.
By the police.
Here, my lord, the CD is till 1610, my lord, because CD came earlier. CD is till 1610. Interim is granted on 24/10, my lord. So that is not reflected in the CD.
And his statement is not here.
Because the CD came much before, my lord. On 24/10, he was given the interim. The CD is till 1610.
I appeared on 27th October.
28 and 27th. Here we have to make the updated.
Just see the one thing.
Yes, yes.
On 21/10, there is an order, 21/10/2024.
Yes. 24, yes.
When case diary has been received, it's detained.
Yes.
And same be detained.
Retained.
That is the order.
Yes.
So it was detained.
Retained.
Oh, that means 1610 only it comes.
Yes. 1610 it came, my lord, because it
Acha.
was listed on 2110.
Then 2410 the order was passed.
2410 order was passed.
But order was passed after perusal of the case diary or
It reflects whether document kindly peruse the order.
there is nothing in the case diary regarding
Nothing.
ownership the how the petitioner may appear. Acha. Acha. Oh, so you are on interim.
Yes, Lordship.
Let the updated case diary be called for because your statement and you have submitted that the kettles were already returned to you. That is not there in the case
Yes.
diary. So simply koribo.
You can have a report whether he has appeared or not. Just
In that case, you want to retain the case diary?
retain then, because again it will go again, because
No,
if he has-
retainment will be a different thing because his statement has to be there. Only if it report is sufficient, then it's okay. But I don't have anything to say. What do you want to say? Report only report.
Otherwise, I will send back, my lord.
Because he is an interim.
Yes.
I will
That-
be given some more time. But Mr. You are Mr.
M. Ahmed.
M.
Ahmed.
কোনটো নম্বৰ লৈ আছো আচ্ছা এম এম কৰি দিব Mr. MP Goswami কৰি দিব it is submitted by Mr. Goswami that the CD received but the last date of updating in the case diary is on 16/10/2024 and hence 16/10/24 and the order of interim pre-arrest bill was passed on 24/10/2024. Accordingly, Mr. Goswami submitted that the updated case diary would be required. Full stop. Let the updated case diary be called for. This matter accordingly. Let it be after vacation only. Yes. 9th of January. 9th of January. 9/1 করে দিব till then interim be continued. Your interim will be continued till next date of list.
Deeply obliged, Lordship.
25.
Yes, 25. What is the position?
Case diary was called for, my lord.
Hmm.
আপনার আবু মোহাম্মদ সাইদ
He did not receive in this case, madam.
there is no interim, my lord. Short date, my lord.
One finally a date may be given.
Patharkandi.
Patharkandi, madam. Karimganj.
Karimganj.
So now
I think it is.
Very short
On
date will
9th,
not
madam.
suffice.
very
Nine-
short day will also not be.
that's-
9th, madam.
Can it be expected by 9?
Yes.
Okay.
9th or 10th, madam.
10th.
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 12.
CD not received. Issue reminder. List on 10th. For you.
Very well, very well.
44.
May I please, Lord?
Yes.
Here, Isner is my lord, behind the bar for the last 86 days, my lord. Matter pertains to the trading, my lord. Lordship will find as a fire case 10, my lord. CBI. Case 10, my lord. FIR.
44.
44.
Here, hello is there, I think.
CD just received, lordship.
Hey, my lord, petition.
He can make his submission, I'll make my reply.
Will you be able to peruse the CD during that time because his simple submission is that he is behind the bar since last
On the length of
81
detention.
days.
On the lordship, length of detention cannot be a ground for releasing an accused of the lordship. The gravity of the offenses, that is settled law, lordship. If that is his only submission, my reply will be there. And lordship, we are going to file the charge sheet and some prime witnesses are yet to be examined, lordship. That is the difficulty. Not at this stage, it should not be released on bail. That apart not on merit, lordship, if he is not arguing, lordship, and even then, lordship, we have flag mark all the relevant entries and statement of the witnesses is the prime accused, lordship. He induced people to believe that they are giving profit, lordship. Huge number of
money has been collected by this accused person along with other accused persons. There are three more accused persons are there, Lordship. They have collected money, and Lordship, this money has now then been taken to their own account, Lordship. So it has been converted to their own use, Lordship. So at this stage, Lordship, I am praying for rejection of the bill, Lordship.
My lord, here I am paying for the default bail, my lord. The coordinate batch is already held, my lord. There the mandatory period is only 60 days, my lord. In this case, my lord, here the sections which IPC has been inserted, my lord, that is not attracted because the FIR was lodged on 3/9/2024 after repealing of the IPC, my lord. So the already the coordinate batch is held, my lord. Let me kindly have the It pays 18, my lord, para 35, my lord. Page 18, para 35, my lord. Admittedly, charge sheet was not filed within the 60 days. In this case, it appears that the accused petitioner arrested on 4/9/2024. Here, my lord, the petitioner is also arrested on 3/9, my lord, and forwarded 4/9, my lord. And the case was registered under section 3162, 318 BNS, read with section so and wherein the mandatory period of the custody is 60 days. Section 409 IPC was added on 29/4/2024. By that time, the IPC was repealed. Section 3165 of the BNS was added on 11/11/2024. And during such period, the mandatory period was over. Hence, the petitioner entitled for default bail. My lord, may kindly have a look at the FIR, my lord, at page 10, my lord. Page 12, my lord. Page 12, my lord. Here the sections are registered under section 120B, 420, 409, 50 IPC, my lord. That will not attract. Only against the petitioner, my lord. The birth sections are attracted, my lord. 21(1)(3), 23, 25, the banning and regulatory scheme act 2019, my lord. So petitioner entitled here the mandatory period is 60 days, my lord. So he is entitled for default bail, my lord. And he is behind the bar for the last 86 days, my lord. And coordinated with have granted almost 6 or 7 petitioners, my lord, accused persons.
Out of same FIR in this coordinate bench order?
Same note, but same footing, my lord. They are
No,
FIR is different.
for different aspect I'm asking.
Yes, my lord. Their FIR is different, my lord. Here the FIR was lodged on, my lord, 3/9, my lord. At page 10. And he was arrested on 3/9, my lord, on the same date, my lord. Here against the petitioner only birth sections are attracted, my lord, and that is mandatory 60 days, my lord. So he's entitled for default bail, my lord. Moreover, my lord, he is not an employee, nothing. He himself invested in that company, my lord. That company name is the Titan Capital Market, my lord. And the informant himself invested in that company also by creating his own account, my lord. That I have also stated in para, my lord. May you have at page 4, para 5, my lord.
In regards to the section 3165, your submission is
My lord,
with the
that has
coordinate
not-
bench.
My lord,
This submission is in with coordinate bench or what?
my submission is that, my lord, the section which says inserted, my lord, IPC has already been repealed, my lord. And the FIR was lodged on 3/9/2024, my lord. So in this case, my lord, IPC will not attracted, my lord. Only birth sections will be attracted. And that their punishment is their mandatory period is only 60 days. Only banning of unregulated.
No, after repeal, suppose the IPC is not there now, the BNSS.
Yes.
Why BNSS 3165 will not take as per your submission?
My lord, that in this case, whether I do not know whether they have been inserted or not, my lord, they have made or cleared or not, my lord, added or not this section, my lord. In this case, my lord, I think As per my knowledge, my lord, that has not been added, my lord.
Not yet added.
Not yet added. And if it is added, my lord, then also the after expiry of the 60 days, my lord, they have added. My lord, give me
If he has completed, I'll make my reply.
316 head quarters.
আপনার হলে না পরে শুনুন আপনার হোম সাবমিশন
If you want to see, you can see, because if you are in confusion.
Because my
confusion
lord, as
whether
per my
three
knowledge, I have checked the record, my lord, when before filing of the case, my lord, I have checked that the CBI court, my lord, 3165 was not added at that period of time, my lord. But if in between the it has been added, my lord,
And
then
that's why I'm asking you, if you are,
that
if
will
you are in
clarify, my
confusion,
lord.
if you have not gone through the case record, just
lord, he
you
will
should
clarify it.
come. I'm not in a position to say anything because records are now before me. So whether 31565 is added or not.
As
that
per
I'm-
my laws, but it has not been
But
added.
after repeal, I just cannot,
That has been
not
elaborately,
convincing
my
with your argument. After repeal added, then why not will not attracted to this?
IPC,
I'm not.
those cases which has been, my lord, lost after 1/7/2024, my lord, there should be registered under BNS, my lord. That should not be registered under IPC, my lord. That has already been repealed, my lord. And that is also clarified by our High Court judgment also, my lord. That's
what I understand, Lordship. He wants to say
He
that
wants to say what?
he wants to say that IPC offense is not applicable and
In this case.
BNS Act offense is also not applicable.
No, BNS will attract.
So he's
Where
saying
I-
BNS Act applicable.
BNS will applicable.
Only
I'm just that's why I'm asking you. Now, yes,
Only, my lord,
IPC,
the BNS was
after
the-
1/7, IPC is not there, and I can
Yes, my lord,
understand.
my lord.
Now you're saying that IPC may not be attracted, whether BNS will be attracted as per
BNS will
you.
be attracted, but the BNS, when the BNS sections were added, my lord, that is the point, my lord. They have, BNS has been added only after 60 days of mandatory period, my lord. The bird section, those which will be inserted, my lord, here, my lord, their mandatory period is 60 days, my lord. And after expiry of that 60 days, my lord, they have added that 3165, my lord, BNS. Added or not, in that regard case, I have said, but in this case, whether it has been added, I don't have.
What I understand, Lordship, he wants to say that after expiry of the custody remand period, CBI might have or may not have added 3165.
So till
That
the
is-
filing of my case, my lord, it was not filed.
If you interrupt me,
No, no, I am
I
not
won't be
interrupting.
able to make the position clear. That is his stand, if I'm not wrong. Whether 316 has been added, no, Lordship, we have not added. Why we have not added, Lordship, I'll make it clear, Lordship. Why we have not added? Lordship, there is a, the judgment which has been rendered by Justice Malasi Nandi, the fact of that case and fact of this case is altogether different, Lordship. First thing is that here the offense is a continuing offense. 409 is a continuing offense. And Lordship, the initial FIR, which has been registered, Lordship may kindly have a look into the FIR. It has been registered by the Assam Police. It has been registered by Assam Police, page 12. Page 12, Lordship may kindly see. Assam Police has registered it on 3/9/2024. And they have added section, IPC sections and as well as BAT Acts, Lordship. We have not made any change and neither we have added any sections of DNA. Why we have not added? Because the transaction, Lordship, which has been taken place with the money transaction is prior to the coming into force of BNS. It is a continuing offense, Lordship. So my respectful submission, Lordship, 3156 is not required at all, Lordship. 409, Lordship, criminal breach of trust by public servant, if your Lordship see it over here. BNS for so code number 3 is again. No, IPC. Lordship may kindly have a look into 409 once. I made that submission before the learned that court also. But the fact of that case and this case is altogether different. Their Lordship 316 has been inserted. 409 may kindly criminal breach of trust. Criminal breach of trust, Lordship, by public servant or banker or merchant or agent. So they falls under the category agent.
they fall under this petitioner fall under the category agent because these petitioners along with 3 other persons, they are insisting people to invest their money in the company. And subsequently when they invest, those money has then subsequently been taken into their own personal account. So Lordship, criminal breach of trust is an offense which may be occurred in a single day. It may take 5 days also to complete the offense. It may take 5 months also. It's a continuing offense, Lordship. The first ingredient which is necessary is, Lordship, the entrustment of the property. The entrustment of the property is required and subsequently it has to be misappropriated. So on a single day also, if a person entrusts on property, he may misappropriate it on a single day. He may not also. It may continue for 5-6 months also, 1 year also. If a person came to know that after 1 year that the property which has been entrusted to so and so was subsequently misappropriated. So it's a continuing offense, Lordship. So therefore, 409 is applicable, and there is a division bench judgment of this honorable court regarding the repeal act. What would be the act that is applicable even if the act is repealed? In case of IPC offences, it is very clear, Lordship, with regard to the Article 20 of the Constitution, no person shall be convicted of an offence which is not in existence. Here also, Lordship, the transaction of money which has been taken place prior to the Lordship coming into force of BNSS has been taken place. So from 2023, people are investing money on their account. So offense start from 2023, Lordship. So therefore, even after the act has been enforced after 1/7/2024, Lordship, that offense will be attributed, Lordship. 409 IPC will be attributed. Therefore, the stand that they are taking that it is a not BNS Act will be applicable. 409 is not applicable. It's a wrong submission. I'll read the relevant portion of. I'll place the judgment also. The division then judgment of this honorable court, Lordship, what this judgment speaks, Lordship, from para 17, Lordship. I'll make it clear, Lordship. Okay, you can keep this now. Lordship, criminal reference 1/2024. The Lordship will get in the computer also, Lordship. RE versus State of Arunachal Pradesh.
Criminal reference, that's it.
Criminal reference 1/2024. 1/24. Criminal reference 1/24. RE versus State of Arunachal Pradesh. May I read, Lordship? Otherwise.
Yes, you can read. You'll get the copy.
The division bench of Allahabad High Court, while interpreting section 531 of BNS, that's the saving and repeal clause 531 of BNS, has expressed the same view in criminal miswrit petition number 12287 of 2024, D2 versus State of UP and others, order dated 6/8/2024. The relevant portion of the above reference judgment is extracted here. From the perusal of the above section, it is clear that if any investigation is pending on the date of repeal of CRPC, then same will continue as per CRPC. As per section 157 CRPC, investigation would start from the date of registration of FIR. Therefore, if FIR is registered before commencement of new criminal law, then the procedure of investigation will continue as per CRPC, because investigation will be deemed to be commenced on the date of registration of FIR. However, in case the FIR is registered after the commencement of new criminal law for the offense committed prior to the enforcement of new criminal law, then the FIR would be registered under the IPC. So, as the IPC is a substantive law which was prevalent at the time of committing the offense, because as per Article 20 of Constitution of India, a person cannot be convicted of an offense. That's what I have stated. For the violation of law enforced at the time of commission of the act. However, the question arises, what would be the procedure of investigation if the FIR is registered after the commencement of new criminal law for the offence committed prior to the enforcement of new criminal law. As such, the investigation got saved by section 531 2A of the BNS as to be conducted as per CRPC. To decide this issue, it is relevant to consider section 6 of General Clauses Law, which provides effect of repealing of any central act or regulation. Section 6 of General Clauses Law is being quoted at the under. So, Lordship, effect of repeal act, it will, Lordship, may kindly come to page 11, 16 and 11. So, Lordship, got the judgment. Page 11. Para 9. Relevant, Lordship, before para 9, there is a para 8. Extract of the Dipu judgment of Dipu versus State of UP. Para 8 is relevant. Possibly,
yes.
note para 8 of that page 11. Para 8, it was the extract of the Dipu judgment, the relevant portion of adverse judgment is extracted.
No, no, para 8, you're saying?
Yeah. The extract, page number 11, may kindly look at. Page 11.
Page 11 is something. What the line starts from?
It starts from page 11. Petition.
No, line starts with which word?
Petition number 12287. 11.
Page 11.
1 oblique, prevented reference 1 oblique 20.
This one is 11.
Yes, sir. Para 8, Lordship, which is extract of the judgment of Honorable Allahabad UP, Lordship, Allahabad Court. Para 8. Now, I have already read para 8, Lordship. Then the repeal was effect of repeal was para 6. I will not read the para 6 again. Para 10, Lordship, next page, Lordship, para 12, page 12. From the perusal of section 6 of General Clauses, it appears, may I read, Lordship? From the perusal of section 6 of the General Clauses Act, it appears that the repeal of CRPC shall not affect any investigation, legal proceeding, or remedy in respect of any liability, penalty, or punishment accrued or accrued under the Repeal Act, and such investigation, legal proceeding, or remedy will continue under the Repeal Act. It is also clear from section 6 of General Clauses Act that the repeal of IPC or CRPC will not affect any right, liability accrued or incurred under the Repeal Act. Therefore, despite repealing of IPC and CRPC, liability to get punishment under IPC will continue, and remedy like an appeal under CRPC will remain as it is. But the forum of appeal, being procedural in nature, will be as per the BNS. So, Lordship, it is clear, Lordship, that IPC will prevail even after the repeal act. If the offence is commenced prior to the repeal of IPC. Finally, Lordship, if your Lordship go subsequently, the same thing has been. Lordship, now then come to para 16. 16 is the finally what is the observation of this Honorable Court. Page 13, Lordship. Page 13. On the basis of above analysis, this court, means this High Court, Division Bench of this High Court, is also summarized the law regarding effect of repealing the IPC and CRPC by BNS and BNSS respectively, and the same is being mentioned as below. If an FIR is registered on or after 1/7/24 for the offence committed prior to 1/7, then FIR registered under IPC. It is clear, Lordship. Here, Lordship, we have registered the FIR under BNS, but the IPC offences are under IPC. Therefore, we have mentioned IPC offences. There is no need of adding BNS sections of BNS. But the investigation will continue as per BNS. So, if you register the FIR after coming into force of BNS, Lordship, the procedural will have to be followed by BNSS, new law, new act. But the offense, as because it's a continuing offense, they, in this case, Lordship, they are taking money prior to the repeal act. 409 it is a continuing offense, Lordship. So therefore, IPC offense will be applicable. in this
He is
case.
submitting from some other cases, my lord. He kindly go through this FIR, my
Now
lord.
he's interrupting. You submit.
No, no submission. You can-
Why are you interpreting? I have not interrupted you when you are making a submission. Your lordship will see from the CD from which this accused person are inducing people and they are taking money. The CD will reveal. No, I'm not making my statement out of nothing, lordship. I'm making my statement on the basis of material available on CD. Your lordship will peruse the CD, and if the CD doesn't reflect any money to be transferred in their account prior to the repeal act, then I think he's right. Lordship may kindly have a look into the CD.
My lord, may kindly have a look to the FIR, my lord, page 10, my lord. When the incident was took place, my lord, may kindly FIR. His submission is that the incident was occurred prior to 1/7/2014, my lord, 24, my lord. My lord, may kindly have a look to the FIR at page 10, my lord. If this is his submission, my lord, then. FIR will page 10, my lord. The FIR was lodged on 3/9/2024, my lord. May I read, my lord? With due respect, I beg to state that on 25/7/2023, my lord, may kindly have a look at the date. 25/7/2020.
Page 10.
Came to the below mentioned accused person came to my house with 2 numbers of 4-wheeler vehicles, introduced themselves as senior executive partner, and senior executive partner of Titan Capital Market online trading business. All the 3 accused persons said to me that how much money I have to deposit in the said bank and I will get 30% as interest in the every month. My lord, may kindly have looked at page 5, my lord. Page 5, page 4, my lord.
Jumping, read the.
No, page 4, my lord. Page 4, my lord. Page 4, para 5, my lord. Here, my lord, I am not an agent or nothing. My lord, I
Page
have
4,
only
para 5 of your petition.
my petition, my lord. At page 4.
No, you are reading on FIR only.
My lord, I have
Not reading. Achha.
At page 4, my lord. Fact, my lord, that I have this. They himself, my lord, the informant himself created an account, my lord, and he has deposited that amount. May I, page 4, para 5, my lord. Case is that the allegation is the FIR totally false, my lord. And petitioner is not the executive member of the company Title Capital Market. The company Title Capital Market is an Australian web-based global forex trading company, and anyone of any part of the world himself can trade forex at the said company's platform. The informant associates have themselves invested the money at the company's platform by providing their details and creating their own ID. My lord, anybody can create their own ID and he can invest, my lord. This is a foreign company, my lord. It is not that any agent is required, my lord. And moreover, the Title Capital Market being forex company is not within the purview of the banning of unregulated deposit scheme Act 2019, and it has not been banned or declared illegal by the Indian government till today, my lord. It has been running, my lord. Apart from this, the petitioner himself invested money in the said company, and he is not an employee or agent of the company. The informant himself invested his amount by creating his own ID number Ahmed 31, and these are facts has not been he is stated in the FIR, my lord. He himself invested, my lord, because this is an online platform, my lord. Here there is no requirement for any agent, my lord. And petitioner is not an agent or nothing, my lord. And 86, my lord, considering the detention period, my lord, 86 days already is gone, my lord. Only 4 days later, and court was granted so many percent money that I have already given, my lord. And my lord may kindly
You are
go through the
in custody since last 81 days or
86 days, my lord.
86 days.
Yes, my lord. I was arrested on 3/9, my lord. So, my lord, considering the length of detention also, my lord, he may be enlarged on bail, only recondition, my lord. Because the other co-accused has already been enlarged on bail in some other cases, my lord. And my lord may kindly go to that order that I have given.
I'm just asking you, in this case, in the, out of this FIR, how many accused persons are there?
As per FIR, my lord,
Three accused persons.
Three.
One is yet to be arrested, I think. One is yet to be arrested.
Two already got arrested, and this petition is filed by only one.
only
or-
one, my lord.
One. Yes.
Lordship, the scheme which is referring to MLM scheme, multi-level scheme, multi-level marketing scheme, Lordship. In that scheme, opening of one account by the individual is required, Lordship. After opening the account, that money which has been deposited in that his account, it has to be transferred to another account. And in this case, the money which has been deposited in their own account subsequently has been transferred to that account of this accused person and another person. But the scheme is that. And your lordship, he has stopped reading the entire FIR. If your lordship goes to the entire FIR, there are lordship deposits from other accused accused persons also. But lordship may kindly have a look at the FIR again. Let us read. Page 10, lordship. Start from where he has left, lordship. No problem. All the three accused persons state to be that how much money I deposit in the said company, I will get back 30% as interest in every month. And I can withdraw my deposit amount at any time as per my wish. They also said that they have been doing this business since long back and got opportunity to travel in abroad. They also said that they have earned lot of money and able to purchase house, land and vehicles through this business. By giving this type of enticement, the accused person took rupees 1 lakh cash and through online. Cash has also been taken and online also. 2 lakhs to 2,000 has been taken through online. That is rupees 3 lakhs 2,000 from me. Rupees 1,15,000 from my elder brother, Moinuddin Ahmed. Rupees 1 lakh from my brother-in-law, Islam Sahid Raja, and rupees 75 from his wife. After expiry of 1 month, when we ask for the interest as above said deposit amount, then accused person have not returned our money, showing loss of the company. And by giving life threat has been given. Misappropriate our above mentioned money. Later, we have come to know that the accused person misappropriated crores of money of different persons. So the FIR is not confined to only this person which has been mentioned. FIR is now reveals that he misappropriated the money of different persons. So investigation on that line is going on. So it cannot be said that only the amount of the complainant is there. And if your lordship see the name of these accused persons which are reflected in this FIR, in the material, bank statement, it will reveal lordship, they are taking money and investing money prior to enactment of BNSS and BNSS, 1/7/2020. So the stand lordship that they are taking that IPC is not applicable is not lordship sustainable lordship, is incorrect proposition of law. And therefore lordship, the division bench of Honorable Guwahati High Court itself has lordship mentioned and lordship laid down the provision which are applicable lordship. From this reading of this provision, it's clear lordship, IPC is applicable even after it was repealed, if the offense is committed prior to the repeal. That's my respectful submission. At this stage, considering the length of detention is not lordship, the prima facie things lordship. Length of detention, if the gravity of the offense is high lordship, from the reading of the FIR, for also proof lordship. Let us examine lordship. 60 days, 90 days is not applicable here in this case. Looking into the gravity of the offense lordship. So at this stage, I'm saying not to really bring on.
60 days, 90 days. If it is not suppose applicable, you cannot keep a person behind the bar for.
Correct one. Why Jagan Mohan Reddy lordship, even after 60 days and 90 days also, one can be investigation could not be completed. Lordship may kindly have the look into the why Jagan Mohan Reddy.
Everything has been seized, and all the documentary evidence has been already been seized, my lord. And there is no possibility, my lord, he can escape, my lord. In any condition, my lord, 86 has been gone. No, co-accused has already been enlarged on bail, my lord, so many persons. Co-accused means in other cases, my lord,
Another case is another case, Lordship. We are referring to why are we
because they have
referring to
80
other-
days, 81 days,
grounds
my
are
lord, they have been
different.
enlarged on bail, my lord.
They are
So
on
all the
different
cases are
footing.
the same, my lord.
They are on different footing. This case is on a different.
Definitely, my
footing.
lord, custody, my custody intervention is not required, my lord. For debt, my lord. Custody is your, my lord.
Custody is required because we have not yet filed a charge sheet.
On any condition, my lord, 86 is, my lord, only 4 days is left, my lord.
And Lordship, numbers of witnesses are yet to be examined, Lordship. We have
Definitely, my lord,
collected
they
and
could
Lordship, we
not
have
be able to complete, my lord, in 90 days, my lord.
subsequently, Lordship, this document initial has been seized by Assam police. It has been handed over to CBI very lately, Lordship. Therefore, we need time to investigate, Lordship. It's a case of documentary evidence.
It is my
And Lordships, meticulous perusal of each and every entry is required, Lordship. It's not like recording of only evidence, Lordship, witnesses. You have to see the meticulous perusal of the entries, and it has to be tallied with the UPI. You have to take evidence and who are
You
the
are
persons.
referring to which judgment, Jagan Mohan?
Why is Jagan Mohan Reddy, Lordship? Oh, 2013, if I'm not wrong, Lordship. Lordship, I'll give the judgment. I'll place the judgment after some time.
And regarding the merit, if I need to submit, no.
My lord, everything has been seized and all the.
No,
the
no,
case is
regarding
in-
merit, anything is to be submitted?
Yes, my lord, I've already seen them.
No,
Because,
no,
my lord,
regarding merit of the case, you have said.
because 86 is, my lord, and everything has been seized, my lord, the document, and the case is depend upon the, my lord, documentary evidence. My lord, it is not the case that after release of bail, if they want any investigation and he will not cooperate, my lord. That is there, my lord. So his custodial intervention, that is not required, my lord. Is the everything is a documentary evidence, my lord. And what is the requirement of his custodial intervention, my lord? It is not that everything has not been seized, my lord. All these things has been seized, my lord. And a person is not, they are not being able to catch a co-accused, my lord.
We are human beings.
Definitely, my lord. But if he is not being caged, my lord, then I will be put in behind the bar, my lord.
We are trying our best, Lordship, to trace out the other accused also. Every effort has been made by CBI to apprehend the other accused also. And we are expecting very soon we are going to apprehend him also, Lordship.
And length of detention may be considered, my lord. 86 days, my lord.
नहीं जाते हैं तो बॉय जगन मोहन रेड्डी लेकिन सुप्रीम कोर्ट
CD2 DD1. Okay.
Hello.
Funding 22.
May please, Your Lordship. Lordship will find a FIR at page 16.
CD has come, Lordship, but I will need some time. Already CD just arrived. It will be at 2, Lordship.
Let me submit.
Oh, yeah.
Let me submit, Lordship. With reference, Lordship got it, page 16.
Page?
Page 16.
16.
16. The FIR dated 9th of August 2024. With reference to the subject cited above, I have the honor to inform you that it is recently observed that a trading website in the name of ybfunds.com is going widely used by the people of Assam and all over India as a trading website which deals with stocks and equity. Recently, it is seen that many people have been cheated with huge amount of money by the administrator, member and creator. This is important, Lordship. Administrator, member and the creator of the website. The victim have been seen expressing their grievances in various social media platforms such as Twitter, Facebook, etc. Based on that, a preliminary inquiry was conducted wherein it is seen that the administrator, proprietor, and creators have been committing cheating, misappropriating, and criminal breach of trust in an organized way. It is also pertinent to mention that number of similar application sites have been cheating the common people in the name of stock brokerage, the list of which is enclosed here with for kindly reference. Lordship, if I may take your Lordship to the paragraph 6 of my application, Lordship, at page 6. Page 6, para 6, 7, and 9, I mean. Page 6, para 6. That the actual fact is that the petitioner number 2 received a trading advertisement link post of YBY Fund app in his Facebook, and accordingly he clicked the link and then agreed the terms and conditions to get registered himself in the said YBY Fund app. And therefore, by mistake, he joined the said app due to ignorance. Thereafter, the said Facebook account was linked with the WhatsApp number, and in his WhatsApp number, different WhatsApp calls were made almost regularly, and thereby tried to influence the petition number 2 to join the app. And he get high bonanza profit at the rate of 15 to 30% per transaction, that is per month. Paragraph 7, Lordship. The petition number 2 has succumbed to the aforesaid lucrative offers made by the administrator, member, and creator of the website. And on such influence, the petitioner number 2 has invested ₹600. Only gradually thereafter, number of people joined in the said website, and the amount invested by the petition number 2 and other people, those amount were credited in the wallet form, and the said wallet and amount of ₹500 was credited to the saving bank account of the petition number 2. Number 8, Lordship. That having found that the petition number 2 by investing the meager amount of ₹600 has earned ₹500 in a month, accordingly the petition number 1 shown considerable interest to join the said website, and thereafter he also joined the said website by investing ₹600 only. Thereafter, an amount of ₹500 was credited to his bank account through wallet. Paragraph 9, Lordship. That the petitioner get to state that they become greedy, having found easy earning process. Accordingly, the petitioners have invested money in the said website ranging from ₹10,000 to 50,000, and for a couple of months, 20% were credited to their bank account from the total invested money. Also, that several people joined the so-called YBY trading app, and money automatically debited from the particular person account and credited to the scamster account. This is important, Lordship. This money has been credited to the scamster's account, not in our account. Therefore, a list was prepared showing the name of the person and the investment made by them for fair transparency. Therefore, the list which was seized by the CID police at serial number 7 from the petition number 1 is not the broker list. The list showing the name of the persons are the investor, but the CID police, without any verification, has deliberately stated to be the broker list. The petitioner and the other persons who have joined the said website are the users. We are the users, not the administrator, creator, or member. Lord. User and not the administrator, member, and creator of the website. As such, they have been falsely implicated in this. Now, Lordship, this is a digital scam, Lordship. This is a digital scam, cyber fraud by the scammer, and not by us, Lordship. We are the users. We have invested money. We are the victim of the circumstances. Scammer is liable for whole money transaction. Transaction on the account of the scammer, nothing recovered from the present petitioner's Lordship. Even there is no public complaint also, Lordship. There is no public complaint. Because every transaction is done in their own device, Lordship. In their own device. To the scamster link. And it is linked to the scamster, Lordship. On online payment through QR code scammer. To QR code scammer, Lordship. And so far it's the Lordship, I will refer some of the judgment, Lordship. Supreme Court of India, P. Chidambaram versus Director of Enforcement, which is decided on 14/4/12/2019. Paragraph 21, Lordship, as well. '20 and 21, Lordship. Running page 9, Lordship. Lordship got it to page paragraph 20. The learned senior counsel for the appellant has also placed reliance on the decision of the decision of the case of Sanjay Chandra versus CBI 2012-1 SSC 40. The specific reference to paragraph 39, which read sets under. Coming back to the fact of the present case, both the courts have refused the request for grant of bail on two grounds. The primary ground is that the offence alleged against the accused person is very serious, involving deep-rooted planning in which huge financial loss is caused to the state exchequer. Here, there is no state exchequer has nothing to do with it. This is personal money. The secondary ground is that the possibility of the accused person tampering with the witness. In the present case, the charge is that the cheating and dishonestly inducing delivery of property and forgery for the purpose of cheating using as genuine a forged document. The punishment for the offence is imprisonment for a term which may extend to 7 years. It is no doubt true that the nature of the charge may be relevant, but at the same time, the punishment to which the party may be liable, if convicted, also bears upon the issue. Therefore, in determining whether to grant bail, both the seriousness of the charge and the severity of punishment should be taken into consideration. The said case was a case of financial irregularities, and in the said circumstances, this court, in addition to taking note of the deep-rooted planning in causing huge financial loss, the scope of considering relating to bail has been taken into consideration in the background of the terms of sentence being even 7 years of convicted. And in that regard, it has been held that in determining the grant of bail, grant or otherwise of bail, the seriousness of the charge and severity of punishment should be taken into consideration. Now, paragraph 21, this is important. From the cumulative perusal of the judgment cited on either side, including one rendering by the constitutional bench of this court, it could be deduced that the basic jurisprudence relating to bail remains the same in as much as the grant of bail is a rule and refusal is an exception. Grant of bail is a rule. This is the constitutional bench. Rule and refusal is exception, so as to ensure that the accused has the opportunity to secure fair trial. However, while considering the same, the gravity of offence is an aspect which is required to be kept in view of the court, in view by the court. The gravity for the said purpose will have to be gathered from the fact and circumstances arising in each case, keeping in view the consequence that would befall in the society in case of financial irregularity. It has been held that the even economic offence would fall under the category of grave offence in such circumstances. While considering the application for bail in such matter, the court will have to deal with same being sensitive in nature. Allegation made against the accused. One of the circumstances to consider the gravity of the offence is also the terms of sentence that is prescribed for the offence the accused is alleged to have committed. Such consideration with regard to the gravity of offence is a factor which is in addition to the triple test of the triple test that would be normally applied in this regard. What is also to be kept in respective of is that even the allegation is one of the grave of economic offense is not a rule, but that bail should be denied. Lordship got it. It's not a rule. It is not a rule that bail should be denied. I am reading again also. In that regard, what is also to be kept in the perspective is that even the allegation is one of the grave economic offense. It is not a rule that bail should be denied. In every case, since there is no such bar created in the relevant enactment passed by the legislature, nor does the bail jurisprudence provide so. Therefore, the underlying conclusion is that irrespective of the nature of the gravity of charge, the precedent of another case alone will not be the basis of either grant or refusal of bail, though it may have a bearing on principle. But ultimately, the consideration will have to be on case-to-case basis on the fact and involved hearing and securing presence of the accused. So here the Constitutional bench has referred that the bail is a rule and not exception. Here in this case, we are behind the bar for 81 days. And we are the users, we are the victim of the circumstances. Therefore, considering the length of detention as well as since we are the users, we invested money, now we have been arrested. And main scammers, they are outside lawsuit. And the lawsuit is a Calcutta High Court lawsuit. Paragraph 22 and 23 are. Paragraph 22 lawsuit, running page 14.
Yes.
Section 479 of the Bharatiya Nagrik Surakha Samhita 2023, as it stands after amendment of section 426A of the Code of Criminal Procedure, spells out that the first-time offender, who is the first-time offender, first-time offender who has never been convicted for any offense in the past, shall be released on board by the court as if he has undergone detention for a period extending up to 1/3 of the maximum period of imprisonment specified for such offense under that law. The Honorable Supreme Court in the order passed on 23rd August 2024 in Read Petition Serial number so has made the amendment provision applicable to all under trial in pending cases, irrespective of whether the case is registered against them before 1st of July 2024, when the new legislation came into effect. Here also, the FIR was filed on 8th of September 2024, after the repealing of the IPC and CRPC. Paragraph 23 also. In the judgment of Manish Sisodiya Supra, the Honorable Supreme Court has held that the right of bail in case of delay coupled with incarceration for long period should be laid into section 439 of the Code of Criminal Procedure and section 55 of 2002 Act. The Honorable Court has referred to the authority of Javed Ghulam Nabi Sheikh versus State of Maharashtra and another reported in 2024 Supreme Court case online SC 1693, wherein the Honorable Court has dealt with laws laid down in the judgment of Gotekani and other versus public prosecutor, High Court of Andhra Pradesh, reported in 1978, one Supreme Court cases, 240. Sri Gurbaksh Sibba and others versus State of Punjab, reported in 1980. Hussein Khatun and other versus Home Secretary State of Bihar, reported in 1980, one Supreme Court case. Union of India versus A.K. Najib, reported in 2021, 3 Supreme Court cases. Satyendra Kumar Antil versus Central Bureau of Investigation and other, reported in 2022, 10 Supreme Court. it is the state or any prosecuting agency, including the court concerned, has no wherewithal to provide or protect the fundamental right of an accused to have a speedy trial as enshrined under Article 21 of the Constitution. Then the state or any other prosecuting agency should not oppose the plea for bail on the ground of crime committed is serious. Article 21 of the Constitution applies irrespective of the nature of the crime. The Honorable Court has also observed that the principle bail is a rule and refusal is an exception, is at times followed in which, and it is high time that the trial court and the High Court should recognize the principle that bail is rule, jail is exception. This Honorable Supreme Court has also held that bail is rule and jail is exception, Lordship. Here we are behind the bar for a period of 81 days, Lordship. And we are not the scamsters, we are the users, Lordship. And the scamsters, they are free. They have not been arrested, and no effort has been made, Lordship, to arrest them, Lordship. And we were arrested on 9th of, on the day the FIR was lodged on 8/9/2024, we were arrested. Lordship. Today, it is 81 days. If the production days is given -1 day, then it will be 80 days. And section 316(5) does not attract, Lordship, in this case, Lordship, because we are not the public servant, Lordship. Of the BNS. Section 316, criminal breach of trust. Section subsection 5, Lordship. May I read, Lordship, of the BNS. BNS. Subsection 5. Whoever being in any manner entrusted with property or with any dominion over property in his capacity of a public servant or in the way of his business as a banker, merchant, factor, broker, attorney, or agent commits criminal breach of trust in respect of the property shall be punished with imprisonment for life or with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Here we are neither the banker, businessman, banker, merchant, factors, brokers, attorney, or agent. We are the users. We have invested our money, which has been siphoned by the scamster. This is my respectful submission, and considering the length of detention, Lordship, and further custodial detention may not be required because Lordship may impose any condition, Lordship. I'm ready to cooperate with the investigative team as and when called for. Even 1 week after, if they call me every week, Lordship, I'm ready to. We are ready to. And Lordship, one thing, Lordship, if I may take in, Lordship, to the page 27, this is the public notice which was subsequently.
Page 27.
Page 27, election 5. Sorry, page 26, Lordship. This is the type copy. This is a public notice issued on 14/7/2024. It is hereby notified to all the concerned parties that we noticed a large number of parties that we noticed a large number of individuals are actively participating in the use of YBY fund trading app, which illegal and can be classified as crime in the state of Assam. The government of Assam therefore decided to impose a ban on the operation and the use of the YBY mobile application within the state of Assam, taking in mind the financial safety of the public and their privacy related concern. All individual organizations and entities are hereby advised to cease using the YBY app and uninstall it from their device. for their own safety before the 15th of August 2024. The decision has been made in accordance with the Indian Penal Code of Cyber Crime and Cyber Security of Indian Penal Code, IPC. Failing to comply with the above mentioned notice may lead to unwanted circumstances, fine up to ₹2 lakhs or 3-year imprisonment, or to both the users and promoters. Now, Lordship, if page 28, this is the clarification from the Police Commissioner of Guwahati, Lordship. City Police has taken cognizance of very public notice. That notice which I referred now, Lordship, 14/7/24. The Police Commissioner has informed that City Police has taken cognizance of the fake public notice circulating in social media. It is hereby advised to ignore the fake notice which is on the letterpad of District Commissioner Kamru M. Stamp used is of the SPCID and purportedly signed by the Commissioner of Police, Guwahati. Proof is on the nail the culprit. Proof is on the nail the culprit. Now, if this public notice, the Police Commissioner is making a statement that this is a fake, then the YBY is a genuine, is for the Police Commissioner.
Genuine?
As per the Police Commissioner, if the public notice that is a fake one, then the YBY fund is genuine. It to be genuine, Lordship. And Lordship, another Lordship. What certificate of document was also given, Lordship, at page 25. The Secretary of State of the State of Colorado. This is in California, in the United States of America. This certificate reflects facts established or disclosed by the documents delivered to this office on paper through 2/22/24 and that have been posted and by documents delivered to this office electronically through so-and-so at the latest. I have annexed here with the graded seal of the state of Colorado and duly generated, executed and issued this official certificate at so-and-so in accordance with the applicable law. This certificate is assigned confirmation number so-and-so. Yes, this is the certificate that has been issued by the Secretary of State of Colorado, stating that the YBY is a blockchain technology company limited. So considering that the Honorable Apex Court has also held that the bail is a rule and the bail is exception lawsuit, considering that by respectful submission would be that there would be to release the accused persons of bail. Because further custody detention may not be necessary for the investigation. And if the CBI calls us to cooperate.
I will start with the judgment referred by my learned friend. Bail is a rule and jail is an exception. Very true, Lordship. Now, whether this case, the rule can be exercised to release the accused on bail, and whether the case, this case, falls under the exceptional, exception, falls under the exception not to release on bond. My respectful submission, it's an exceptional case. Therefore, he should be kept behind the bar. The cases which he has been referred to, in both the cases, you'll also see the accused person were languishing in jail for more than a year. For more than a year, they are languishing. He is now only 80 days, not even completed 90 days, which is mandatory period, as per section 13156 of the DNS. So, respectful permission, Lordship, this judgment is not applicable to Dean Lordship. That apart, Lordship, he has stated that Lordship, he is the user. He is a user. They are user. Two petitioners are there. They are user, and not the administrator and non-lordship. In this regard, lordship, we have filed a written objection, lordship. Lordship may kindly come to the written objection filed by CBI. What is the role of this accused person? Will also come to know after reading the written objection.
Yes, your written objection.
I'll not start the whole paragraph, not read. Lordship may kindly come to para 3, page 4. I'll just read, Lordship.
Para?
Para 3 start, the relevant portion, Lordship. I'll read only the relevant portion. The brief of the FIR, with your Lordship, the brief of the FIR number so and so dated 9/8/2024, cyber so and so, is that it is recently observed that the trading website in the name of YBYfunds.com is being widely used by the people of Assam and all over India as a trading website which deals with stock and equity. Recently, it has been seen that many people have cheated with huge amount of money by the administrator, member of the creator of the website. The victims have been seen expressing their grievances in various social media platforms such as Twitter, Facebook, etc. Based on that, a preliminary inquiry was conducted by Assam Police, wherein it is seen that the administrator, proprietor, and other creator have been committing cheating, misappropriation, and criminal breach of trust in the organized way. It is pertinent to mention the number of similar applications have been keeping the common people in the name of broker, stock brokers, etc. In the FIR, Lordship, this is a part of the FIR. Lordship, I kindly skip. Now come to page 5, para 5. The brief of the FIR so and so is the basis of specific input of unlawful activities in Notun Bazar area of Hojai, an operation used by launching by team of Hojai. During the operation, one person, namely Modi Chandra Singha, so and so, was apprehended, and during interrogation, it has come to light that he used a trading app, namely YBY trading app, which deals in unregulated deposits without adhering to the laid down guidelines of RBI and SEBA, which recently become an unfunctional because of the police action. He also revealed that he was introduced to YBI trading by Piyush Kumar Singha, agent about so and so, who made him an agent, and thereby he introduced some other people using the now banned app. He also informed that Piyush Kumar Singha also made him a member of so and so WhatsApp group, which is similar to YBI trading, and asked him to induce more people with false promise of using. Hence, Cognizance so and so has been made out in Hojai. That the investigation of police of cyber PS has examined the victims of Gopur and other parts of the state who have stated that they got the information of YBY from general public victim of Assam who have given them a trading business, namely YBY, and earned lots of money through YBI by joining the people through YBI. They have deposited money of rupees 10,000 through a link for referral code, and accordingly they installed YBI only. After installing, the general public victims deposited money YBI fund by using user ID and password of YBI fund APP and deposit sum of 10,000. After joining, the general public victim did not got any money from YBI. In the month of August, so and so creator of funds asked the KYC the so and so demanded money, what to be 6,000 so and so, in order to withdraw the money from YBI. Some people did not KYC but did not withdraw any money from YBI. They also used one email ID to send the broker's certificate. The email ID is YBI so and so. Now, Lordship, the investigation conduct so far from the statement of general public revealed Oniram Bosumati is very clear the petition already. The investigation conducted so far and from the statement of general public, which is revealed that Sri Oniram Bosumati, aged about 38, son of so and so, he introduced himself to the general public victim as the general manager of YBY Fund app. Sri Oniram Bosumati, along with Meetinga Narjari, he is another petitioner of Gopur and other top level YBY Fund organized a meeting at ITA Maskua and some other parts of place in Assam. They also organized an event at Greenwood Resort, Khanapana, where they distributed around 21 Pulsar bike, iPhone, mobile phone, etc. to the top level agent of YBY app. They have been promoting and advertising YBY app
either directly or indirectly to solicit money from the general public. They have solicited deposit, online trading and in cash by promising higher returns. And they were also convinced and joined the general meeting, general public of Assam in YBY fund to gain money by promising high return. So from this statement, if your lordship sees the statement of witnesses, victims, lordship, it's clear it is this accused person who introduced himself and general manager of that YBY and induced people to believe that they are giving a high return. And accordingly, people were lordship depositing money in YBY. From, if your lordship subsequently from the bank account statement of Oniram Bosumatar and meeting the nursery, it reveals that the accused had banking transaction worth rupees crore, then 100. 1 crore 16 lakhs 95,000, with scores of multiple depositors through UPI, IMPS, etc., with effect from 1 to 24 to 11/9/24. So this is what is the role of this accused person. They are saying that they are not the administrator, but they are the people who have deposited money. They are saying that he is the manager, and they have distributed huge amount of money to the agent also, and they have accumulated huge money in their own personal account also. But if your lordship see, if we have scrutinized the documents which has been received by seized by Assam police, and from the seized document it reveals, lordship, one lakh in the account of Oniram Bosumatar, lordship. Lordship, I will not disclose this. Lordship will go through it, lordship. I have flag marked, lordship. What are the amount he has received in his account, lordship? Bank account statement of on scrutiny, lordship. Oniram Bosumatar, as well as meeting board, lordship. Banking transaction worth rupees 1 crore 80 lakhs, and in another account, lordship, 1 crore 16 lakhs. To UPI and IMPS, etc., with effect from 1 to 2024 to 11/9/2024. Already, lordship, I have flag marked the relevant entries, the bank statement, as well as the statement of victims, lordship. Two CD file, lordship. In one CD file, the statement, bank statement is there, and a lordship chronological, lordship evaluation of the bank statement reveals that crores of rupees has been deposited in the account of both the accused person, not only one accused, both the accused person, crores of rupees has been deposited. This CD will reveal the fact. And here your lordship will find the victim statement of the victim, lordship. Statement of the victim will reveal how they induce the people to invest the money. If they are not the administrator, then why they are inducing people to invest money in YDR? Why they are holding meeting, public meeting they are holding? They are holding public meeting and inducing people to believe that you invest this much of money, you'll get this much of returns. So all these documents speak in volume, lordship, that this accused person, they induce people and they misappropriate the amount of money, and subsequently the YBOI app has been closed, and lot number of public, lordship, have lost their money while depositing in that account, lordship. And lordship, till their lordship, we are investigating the offense, and as per why Jagan Mohan Reddy has given the judgment, lordship, in para, with the exception, lordship, in the exceptional case, therefore, he should not be released on bail at this stage, lordship. Para 15, 16, and 17 are the relevant para, lordship. Lordship, this is an economic offense, and the money of the public has been looted, lordship. Para 15, lordship, economic offense constitute a class apart and need to be visited with a different approach in the matter of bail. The economic offense having deep-rooted conspiracy and involving huge loss of public money need to be viewed seriously and considered as a grave offense affecting the economy of the country as a whole, and thereby posing serious threat to the financial health of the country. Para 6, while granting bail, the court has to keep in mind the nature of equation, the nature of evidence in support thereof, the severity of punishment which conviction will entail, the character of the accused, circumstances which are peculiar to the accused, reasonable possibility of securing the presence of the accused at the trial, reasonable apprehension of the witness being tempered with the larger interest of the public, and other similar considerations. So these things has to be taken into consideration while granting or rejecting bail. Here the severity of punishment is life or more than 10 years. 409 is there, 316, which is corresponding section lordship. And lordship, nature of equation is very serious lordship. Crores of money has been misappropriated by this accused, by inducing people, by inducing public to invest money in the YBY Act lordship. And lordship, they kindly see the 17 para 7, taking note of all these facts, the magnitude, huge magnitude of the case, and also the request of the CBI asking for further time for completion of investigation and filing the charge sheet. Also, this is also without expressing any opinion on merit. We are of the opinion that the release of the appellant at this stage may hamper the investigation. However, we direct CBI to complete the investigation and file the charge sheet within a period of 4 months from today. Even after expiry of 90 days period, Honorable Apex Court has granted time to CBI to file charge sheet after 4 months lordship. Thereafter, as observed in the earlier decision, the appellant free to review his prayer for bail before the trial court, and if any such petition filed, the trial court is free to consider the prayer for bail independently on its own merit without being influenced by the discretion of the president. So even in discretion also, why Jagan Mohan Reddy has been detained in jail for several years. Even after that also, another 4 months time has been given to CBI to complete the investigation to file such report. So my respectful submission, the gravity of the very high economic offense, public way lordship, cheated lordship, money has been misappropriated by this accused person. So at this stage, in the completion of investigation lordship and filing of the charges, this should not be released on bail.
Lordship, so far the allegation that the petition number 1 has stated to be general manager. There is no documents to show that yes, he was a general manager. There is everything was seized by the police, by the CID at the time of arrest. Mobile, bank passbook, everything was seized. Then if the petitioner number 1 has stated that he was a general manager, there should have been some document or appointment letter that has not been found by the CID Assam. So therefore, this is stating that petition number 1 was the general manager. He has himself has introduced himself as general manager. This is absolutely false, lordship. Absolutely false. There is nothing to show on record that he was the general manager. There is no appointment letter. Nothing has been seized. And so far, lordship, that question of program organized at the Greenwood is concerned, it was not organized by the petitioner's lordship. It was digitally organized, lordship. And where money was transferred to the scammer account by the user's account. So far, Pulsar and iPhones are concerned, these are all false, lordship. Therefore, my respectful submission that since behind the bar for 81 days, lordship. So when we pray, respectfully pray before this honorable court to release them in bail, lordship. With any condition, lordship. With any condition. Deep level.
Criminal petition stands allowed. Criminal proceeding has been quashed.
May please your lordship. And I'd like to mention item number 27 of today's list. it has come for orders. Well, actually, it is must come for the hearing because of the 15 matters. If your lordship collected regarding the part payment of the check amount.
Oh,
Yes. That should be come for the hearing, my lord. It is wrongly listed as an order. So I pray for my lord hearing date may be fixed.
Now, at present, what is the position?
Well,
Is
they are
there-
not paid.
Not paying till now. And then hearing maybe hearing.
Yes, date may be fixed, my lord, because of 15 matters, my lord.
May I please, lordship?
No,
Date-
we are not going to hear the matter. We're going to list the matter in the hearing call.
Actually, I am not on that matter.
Excuse not that. I have taken the consent of other side also.
Oh, I thought that, sorry, I thought that you are under.
Yeah,
the
I am
other
not on
side
this
anyway.
matter.
Can it be on the 5th of December, madam? Because it is 15 matters, madam. Thursday.
You are on 27, na?
Yes.
Item number 27. So you are for the respondent.
Yes. On 5th, my lord, December.
Fifth may not be possible. Fifth, sixth, fifth and sixth, lot more. I mean, but can be 12. I mean, it can be.
No, vacation will start from
12.
6th, 4th, 10th, 10th.
10th. 10, 12. 10, 12.
Okay.
At the request made by the Learned Council for the vote with the consent of the other city Learned Council for the respondent submitted that the matter ought to have been listed in the hearing column. Accordingly, the matter will be listed in hearing column on 10-12. We're listing it at 10-12.
May I please, lordship?
Hearing column of the item. Yes.
I have an item today on 37 number item, today's list. In this
37.
case, certain documents were called for, lordship. It is a hearing matter, today's list, from the lower court. But office note dated 26/11 reveals that those documents is yet to be received by the Honorable High Court. Yet to be received. We both parties are here. It may be fixed on 5th of December.
5th of December is not possible.
Or maybe 10th of December. Thereafter, 10th of December or 12th.
As per your record is not yet received.
Record is received, but certain documents were called for.
Documents
From
is
the
to
other
call
side,
for-
documents of the accused side.
Of accused, those who were exhibited in the lower court, that has not been received.
As for office note dated 26/11.
There was a contradiction and there's accused exhibited some documents in the lower court, that has not been received, that has not been checked when record was called. Record has come, but in their record, those documents were not there. I'm for the respondent accused in the lower court.
No, you're for the respondent.
Yes.
And you're
I am for the
Complaint.
complaint. Appellant.
Appellate complaint.
Council appearing for both the parties have submitted that though the record has been received, but certain documents which were exhibited by the accused is not yet received by the registry, which as per the office note dated 18/11, which reveals as per office note dated 18/11/2024. Issue reminder, the registry will do the needful in calling the exhibited documents from the learned trial court below.
Maybe
From
this-
where it has to come?
From CGM court, Guwahati.
CGM Congo. 10, can it be 10? Then the good case. Fixing it on 11 because
11.
10th lot many
Yes.
cases are there.
Yes, yes.
11.
On 11th.
Yes.
December.
Lordship,
11, 12. That is-
Must be.
Lordship, I beg to mention item number 13 of the admission.
130.
13. 13. Lordship. It is listed for consideration of the interim prayer, but probably it will be not reached today.
May not reach.
May
yes.
not reach. Please the matter after vacation, Lordship.
1-3.
1-3.
1-3 cover the request made by the learned counsel for the petitioner MSMD. Let the matter be listed after vacation. Want any fixed date or after vacation? After vacation window. After vacation. Immediately after vacation.
Yes.
Immediately.
Obliged.
So I have a little imbalance, Lordship. But Lordship, two Lordship, can it be taken, Lordship, 34?
34 may not be because one
I have
hearing.
a Lordship, otherwise a suspension, I was convicted. The last day, actually, due to the fault of an advocate, my counsel, myself, I could not produce the document, in order, Lordship. 34. So it's in the motion stage, Lordship. That's the reason I call for this. At the last item, Lordship.
Don't know last item how it will be. Okay. If time permits only, then only. If time permits. If suppose time permits, then definitely we'll take up the matter. Otherwise,
Only there is actually in the CGM.
suspension of sentence has
No,
to
sir,
pass
sir,
the
revision, Lordship, not suspended. 1 year order, 1 year conviction is been given by CGM. And in the electricity matter, Lordship. So it was not circumstantial evidence, the electricity line. It was not 1 year that has been upheld by the session court, Lordship. And in the that is in the that's why I have come as a revision in the work. I have
whatever, it is a revision. And why, what is the IA stands for? Why?
IA is this, the council failed to give the original impugn order, Lordship.
Impugn order was earlier, you have not filed the
Impugn order was not annexed by the council, Lordship.
So through IA, you have filed.
Yes, Lord. It should have been actually. It is the fresh matter, Lordship. It was never been heard, Lordship. Actually, that is
Then it can be listed in motion column then? Can it be?
Actually, tomorrow, today, actually, the time is going on. Today is the last date, Lordship.
It cannot be said at that. If time permits only.
At the last item, Lordship.
If time permits only, we cannot say at this stage.
546.
May I please, Your Lordship?
Yes.
In 45,
You are appealing for 45?
Both.
Oh, both, yes.
Both the cases are arising out in the
One
same
is criminal
FIR,
petition, one is AB.
same FIR and charge sheet, Your Lordship. In 46, I have challenged both FIR and charge sheet, quashing. And in
46, we have challenged FIR and charge sheet from quashing.
In
And 45,
I prayed for bail. That the charge sheet has been submitted showing me absconder, Your Lordship. Then the trial court, without summoning, without issuing summon, on the very first day, issued NBW. And there are 17, I think, 19 times 19 NBW, Your Lordship. The NBW has been served, not yet executed. Service has been completed in item number 45, but in 46 items, service yet to
45, 46 to recently. Now come for 45 now. It is an AB.
AB.
Is connected with 46. 46 is a quashing, and this one is AB.
My humble submission is that, Your Lordship, since if I succeed in item 46, the AB will go, entire proceeding will go, Your Lordship. So in the meantime, in 45, the NBW may keep in abeyance, Your Lordship. Only keep in abeyance. No, there is no stay.
It is already kept in abeyance.
No, my prayer, Your Lordship. Lordship, in 46, in item 46, if I succeed, Your Lordship.
It's a case of POXO otherwise.
POXO is there.
So can you expect POXO? I mean, there may be, I don't know.
There is no.
Otherwise, for POXO is also there.
Yeah. Only I have flag marked the 164 and it says, my lord, the 164, my lord, he is implicated. Also, may kindly peruse, my lord.
This is 46.
Yes.
The victim refused to undergo medical examination, Your Lordship. In 61, she said something. In 64.
Please, Your Lordship. In this case, Lordship, I am appealing on response number 1. On last 29, response number 1. 2 is the formal party state, Lordship. And Lordship, on as per order dated 29/10/2024, I informed this honorable court that 4 years back the petitioner expired. Thereafter, the matter is fixed for on 12/11/2024 for instructions. On that day, the council appearing on behalf of the petitioner for further time for necessary instruction from the petitioner's family.
But as per your information,
yes,
he died.
Died 4 years back.
Your Lordship, we have wrote a letter to the petitioner, Your Lordship. but till now we have not received any instruction from them, Your Lordship. So
Otherwise, the matter is pending now.
yes, Lordship. So Lordship, kindly maybe 3 weeks time may be granted, Your Lordship. For your
You don't have any, I mean, mobile contact number or
No,
mobile number
No,
of any other family members?
we don't have. That's why we have wrote a letter to them, Your Lordship.
Then the possibility is very less than you.
Lordship, we have already wrote a letter. Let them reply, Lordship. Wait for some time. Lordship. Otherwise, there is no urgency in this matter, Your Lordship. There is no any stay orders, and they are policing perhaps the land. So
2018 matter, my lord.
If suppose petitioner is, say is not there or any other one is not there, then if it okay, then I will give him 3 weeks time.
My lordship submitted that they have wrote a letter to the petitioner. Alternatively, may I pray that this honorable court may call for a report from the concerned police station regarding this honorable court may direct the concerned OC of the police station to submit a report.
Can be. Can. Can to do. Can say. Can to solve it. Mr. You are Mr. P.
T. Gogoi, Your Lordship, on behalf of P. Bhattacharya.
Mr. T. Gogoi, appearing on behalf of Mr. P. Bhattacharya, and also Mr. Your Bothakul. Yes. P. Bothakul, the counsel for the learned counsel appearing for the respondent number 1. And also Mr. MP Goswami, the learned additional PP appearing on behalf of state respondent. The learned counsel for the petitioner further sought 3 weeks time to get the instructions regarding the death of the petitioner. In the meantime, Mr. Bothakul submitted in this regard that a report may also be called for from the jurisdictional police station.
The order of
এইটো
cognizance.
এনেকে বাঢ়ি থাকে নেকি? এইটো ইমান স্পীডতে থাকিব নেকি? কমাই দিব পাৰি নেকি? Yes, what you have submitted?
Yes, Your Lordship, this petition has been filed, challenging the FIR, Your Lordship, charge sheet, the order of cognizance, as well as the order of charge, Your Lordship. The Lordship may kindly come to page number 19, Your Lordship, the FIR. Yeah, right, the FIR is that, Your Lordship, I would like to bring to your kind notice that one of our employee who has already been terminated was found engaged into embezzlement of company fund. While dealing with customers against the vehicle delivers, he has inappropriately handled the cash money, and later during the account audit, we found that there are shortage of payment in the cases he deal with. Now, the cases that, Your Honor, this is regarding embezzlement of company fund, and the petitioner before Your Lordship is a sales executive, Lordship. Now, he does not have the entrustment over the property, Your Lordship, firstly. Moreover, in the second paragraph, as it is mentioned, the customers against the while dealing with customers, no complaint has been lodged by any of the customers. No complaint has been lodged by any of the customers, Your Lordship. And in the moreover, it has stated that in the account audits, we found that there are shortage of payment. Now, there is no such document produced by the complainant, the informant side, or has been seized by the police personnel, Lordship, in order to ascertain the fact. Now, if there is any shortage of money, or if any amount has been mishandled or embezzled, that has to be proved by the way of Lordship account statement or by way of audit report. That has not been submitted, Lordship. Moreover, Lordship, there is no any specific amount that is mentioned in the FIR, nor in the charge sheet, or anyway that is alleged to be misappropriated by the present petitioner. Lordship, in spite of that, Your Lordship, Lordship may kindly come to page number 35, Your Lordship. The order of charge, Lordship. By this order, Your Lordship, the present petition was charged under section 408 of IPC, and the charges were framed against the present accused person. So, Your Lordship, in the absence of any complaint from any customers, no audit report, no statement, no bank statement. Moreover, Lordship, in the absence of any document which goes against me, the framing of charges is not sustainable, Your Lordship. So my prayer is that to push this matter, Lordship. The entire proceeding of the case.
That is, I am hearing for the respondent number 2. I lodged the complaint on behalf of the company. After investigation, police submitted charge sheet. First, we come to page 26. Annexure 4, column 7.
Page
26.
Oh, 26. I heard 46.
Charge sheet.
Yes.
Column 7.
Para?
Column 7.
Column 7.
That on 23/2/2019, last informant Pulak Bodhyo, responding number 2, Nexa Pallavi Motors is lost in FIR. That too on their employment Sri Pankaj Bhatto
by name working in the sales used to extract money from customers at the time of selling the vehicles. Facts come to the light of after audit. Accordingly, case was registered and investigations into. During the course of investigation, place of occurrence was visited and witnesses were examined. And accordingly, a case under section 408 of the IPC was established against the accused Pankaj Datta, son of Sancho. And for the charge sheet has been laid before the Honorable Court for trial. The witness named in column 6 will prove the case that is made for being summoned upon them. Thereafter, Lordship, page 35, order dated 16/10/2023, on the basis of privacy materials, charge has been framed against the present petition under section 408. Now case is fixed for evidence. If we can wait for if the witness is proved charge against him, it will be convicted, otherwise it will be acquitted. Since charge has been framed and case is fixed for evidence, so I think there is no case for because charge sheet is very clear. There was sufficient materials against him were found, and the land trial court on basis of that materials frame charge. The case is fixed for evidence, and evidence is going on.
My lord, if I may be allowed to submit a lordship. As my learned senior friend has said, your lordship, in the charge sheet, it is mentioned that the employee so and so by naming working as sales. The sales executive cannot be entrusted with a property, your lordship. This is a company, your lordship. There are a lot of people above my position, your lordship. There are sales manager, there are other also. Moreover, in the charge sheet, it is mentioned the facts came into light after audit. Where is the audit report, lordship? How come the case will be proved against me, lordship? This audit, in the absence of audit report, this in the charge sheet it is mentioned, but no audit report is there, lordship. All the document has been called for by this honorable court. It has been received. There is no such documents, lordship. No interest. There is no statement where to show that there is some interestment over the property. There is no witnesses has said so, lordship. In the absence also to extract money from customers, no customers has given any complaint. There is no such complaint in this case, and no witnesses, no customers has been made as a witness, lordship. Only the officials of the were made the witnesses, lordship. So how come this? There is no independent witnesses otherwise, lordship. Only 3 161 statements, lordship.
Yes.
So this may be personal.
State anything to say.
The city matter. Now the matter test is that whether the for framing the charge matter, the prima facie matter materials are there or not. Whether it will be convicted or not matter, that is a separate thing matter. So on learned matter trial court on seeing the matter witnesses present and complain, they frame their charges. So now my trial will go on. I have flag marked what are the materials against him in the witnesses column. My lordship may kindly peruse the witnesses and the complaint statement. My going for the materials on record, lordship may only see whether the continuation of the proceeding will be by the abuse of the process order. That is what the Rosendahl's case has pointed out while dealing with the case at the time of charge. But from the evidence, from the witnesses, that has been 161 statement. Only the now 161 statements are before your lawsuits and the investigations. And now it is fixed for evidence.
Lordship, that is my point which I would like to raise, Lordship. The continuation of the proceeding would be the abuse of the process of the court, Lordship. Because the only on the basis of 3 161 statement, my lord, charge sheet has been laid down under section 408, Lordship, where is the allegation of embezzlement of company's fund, Lordship. As we have pointed out, Lordship, that there is no audit report, no account statement of the account of the company, Lordship. So, and even then, Lordship, he is not the customer, he is no way entrusted with the property of the account of the company. He doesn't handle the account of the company, Lordship. He's a mere sales executive, and there is a team of sales executives, and he's led by some team leader, Lordship. So in any way, he cannot touch the company's fund. And there is no allegation that any vehicle has remained undelivered due to that this aspect, Lordship, that embezzlement of fund, Lordship. Because the showroom deals with the selling of vehicles, Lordship, Maruti Nexa, Lordship. So that is my humble submission, Lordship. If this proceeding is allowed to be continued, Lordship, pure abuse of process of law will be there, Lordship.
Okay.
Yeah, nice.
How does he do it? That's what I said. Okay. CAB, it will be CAB.
Good.
Well, this is a statutory appeal matter. Petitioner was convicted under section 366 and 370 IPC for 7 years. And he is in. So, my Lordship may admit the appeal. And there is a IA matter. IA, I have annexed all the evidence. So, for the evidences are concerned, my lord. But
okay.
totally, my lord,
now, we are going to admit the appeal. In regards to IA, do you want to file any objection or verbal submission? Because otherwise he is speaking that.
We are not mandatory, but if it requires, I can file because that's not.
Only
No, it's up to you.
Yes,
we are not on that.
Yes.
Condition is of 7 years.
Notice may go.
If the
And he has already submitted the evidence of all the PWs. Other matters I cannot say, but the matters with PWs are there. So that may help you also. In the meantime, we are calling for the guest record also.
So then Lordship may fix a short date because my lord, if your Lordship goes to the evidence, my lord, this total contradiction and no corroboration. My lord.
What do you put that? State is the only party. I think.
Only part.
Do that I for you. I do appeal. Heart Mr. Happy Colita, the learned counsel for the evidence. And also Heart Mr. Gusami, the learned additional PP appearing on behalf of state respondent. This is an This is an appeal under section 415(2) of the BNSS for against its impugned judgment and order dated 04/10/2024 passed by Learned Session Judge Baksa, Masolpur, in session case number 129 of 2022, convicting the accused appellant under section 366 of the 370 subsection 2 IPC and sentencing him to undergo RI for 2 years and to pay fine of ₹2,000 under section 366 IPC in default, SI for 15 days, and also sentenced him to undergo RI for 7 years and to pay fine of ₹12,000 under section 370 subsection 2 IPC in default, SI for 15 days. Appeal is admitted for hearing. Issue call for the LCR. List according. If I am properly interlocutory application note, Heart and Kekolita লিখিব, Mr. Goswami লিখিব, This is an application under section 430 of the BNSS for suspension of the operation of impugned judgmental order dated 4/10/2024, passed by learned session Judge Baksa in session case number 129 of 2022. Issue notice, however, no formal notice is required to be served on respondent. Extra copies of the petition may be served during the course of the day. List accordingly. You want any short date?
Yes, my lord, my learned friend is agree, my lord, lordship may fix it on 13th, my lord. 13th of December.
12, 13, 14, there are lots of 13.
But it will not take
14,
some much more, only 8 witnesses.
14, or only 13, 14. Don't bring it on 17, 18 because there's numbers. 14, 13, 13 of.
Obliged, my lord.
18.
May I please lordship? Yes, sir. Very appeal, lordship. 3 years conviction CBI case, lordship. He is already on previous bail. So till tomorrow bail is there. So lordship will kindly admit and allow him to remain on previous bail.
You have filed one I
For previous bail, lordship. Conviction for 3 years only. 3 years, and he is on bail. 420, 467, 471.
Council is on leg season court number 3. Can the matter be passed off for the time being?
Only appeal, lordship. He is already there.
appeal can be admitted. It is no, I think, because otherwise she may not be in a
Come and
position.
argue this matter.
Lordship, already he is on previous, and petitioner, he is 82 years old and he has faced the trial for 25 years, more than 25 years. So, and tomorrow is the date. that's
He
why.
is in
He is in court number 3.
court number 3, just for a time being.
You have legs.
20.
Yes, please, your lordship. This petition, your lordship, relates to custody of a mobile, your lordship. The petitioner who is a practicing advocate of the High Court, your lordship, was arrested in connection with a case, your lordship, wherein, your lordship, there is some allegation regarding a Facebook post he made. Now, apparently, your lordship, no case under these sections made out. Be that as it may, your lordship, police arrested, granted bail after few days, your lordship, by the honorable court, and his mobile was seized, your lordship. Now, it was in the month of August, your lordship. Now we are in November, your lordship. His mobile has not been handed over. And in fact, what we need is seen, your lordship. Since he is a lawyer, everything, your lordship, contacts, everything is there in this scene, your lordship. That's the problem, practical difficulty he is facing, your lordship. That's the learned court below rejected it, your lordship. Therefore, we have to find the solution on it. Police only wanted only the phone.
Well, yes.
It's part of the report, but it was sent for statement.
And this.
So your mobile was seized on which day? When?
14th of August, your lordship.
14th of August of this year?
Yes, this year. Now we are in the month of November. Now your lordship will kindly see that cannot be a ground that they have sent it to the forensic they have not returned. It's their duty, and in fact, your lordship, if your lordship sees 497, the language of this particular provision clearly says that at the earliest they should hand over the property, either destruction or hand over delivery the property to the owner. 497 of BNSS, your lordship. Order of custody and disposal of the property. 497(5). The court or the magistrate shall within a period of 30 days after the statement has been prepared under subsection 2 and the photograph and videograph has been taken under subsection 3, order the disposal, destruction, confiscation and delivery of the property in the manner specified herein above. From August, your lordship, they are keeping it, your lordship. Maybe they require it, your lordship, some, and your lordship may kindly see the FIR, the allegation, your lordship will kindly see some statement regarding very isolated statement. Your lordship may kindly come to page 18, your lordship.
Yes.
First line itself, you know, say, I have honor to inform you that on so and so, I have come to know from social media platform Facebook that a person namely so and so, so and so, so and so has posted an objection in the Facebook account, Hussein as Sampati Rising or Loradun or Salim movement. This is the statement, your lordship, and on the basis of this, your lordship, they have brought in all the sections, your lordship, 67, 67B, 67A. 196. Yeah. It's a reaction to a certain statement made by the Honorable Chief Minister, nothing more than that, your lordship. And he could have avoided making such statements, that's clear. But still, they have lodged FIR, put him behind bar, your lordship. Now, your lordship, they are giving the mobile also, your lordship. And they are, that it is sent to forensic. Everything should have some limit, your lordship. This is my humble submission. This should be, and at least the SIM, your lordship. Let them keep the mobile.
But SIM is the main ostro, how can?
And
the property is before the forensics laboratory, madam. If they actually went that, my lord, that we have my lord, submitted there for a report, my lord. Now we cannot by force take it out, my lord. If the report is not given, my lord, the property, my lord. So that has to be a separate form that they are not releasing from the laboratory, my lord. In the laboratory, my lord, if they are.
Let them take some instructions from the laboratory, your lordship, whether they need it, they can bring it. Let the matter be kept for some.
Because, my lord, the report has, my lord, the CFL, my lord, that has to be, my lord, along with the SIM, my lord, they could provide the report.
SIM will be required.
Yes.
Not totally mobile. SIM is the main.
Yes.
Okay, if he insists that for a direction to the police to get the to inquire as to whether and then that can be. Heard Mr. S. Botako, the learned counsel for the petition. I also heard Mr. M.P. Goswami, the learned additional PP appearing on behalf of state respondent. Case was fixed for the report and report is already received, which was produced by the learned additional PP. It reveals from the report that the mobile phone along with the SIM has already been sent to FSL Kahilipara to obtain expert opinion, which is not yet obtained by the investigating officer. Accordingly, Mr. Goswami submitted that the IO is not in a position to file any other report as the SIM is as the seized mobile along with the SIM is already sent before the FSL. Next, Mr. Botako submitted in this regard that the mobile along with the SIM was seized from the accused petitioner on 14/8/2024. Until then, the mobile and till then, the seized articles are in custody of police. Accordingly, he insisted that the police may be directed. Police/investigating officer may be directed to obtain the report from the FSL. Next, considering this submission made by the learned counsel for both sides, the investigating officer is hereby asked to obtain the report from the FSL.
Status report from the FSL.
To obtain the status report from the FSL as to whether the there was any examination of the mobile phone and the SIM card which was sent by the investigative. Placed the matter accordingly. The month of January, it has to be placed. January any date also. 20.
Before that, first week of January. By that time, 1 month will elapse. 8th of January.
8
Secondary.
8/01/2025. Which one? They're here. This was partner matter, no? Partner matter. Your part is almost over, I think, and you are supposed to. Well, you have already submitted your.
I have not submitted.
So in reply, you have to
Yes,
submit. Otherwise, I have noted down everything.
Yeah, well, I have already, only thing I just want to rebut what they have.
Yes, yes.
They have filed a written argument.
Yes.
And with due respect to my learned brother and his client, they have almost admitted everything, all my arguments. Because in a criminal case, madam, it has to be point-to-point rebuttal or contradiction. So, Milad, my first issue was that this prosecution was not maintainable in the first place because there is no offense under section 29. That has not been even denied. So, what has been written is, on the third page, fourth page.
Is written argument.
Starting from third page, last parameter.
Written argument.
Written argument, because that is what I'm rebutting. My arguments and my lords have already noted.
Yes, yes, yes.
So last parameter on third page, what my brother has given. Now, whether the accused persons were cutting and clearing the jungle, the answer is positive, as although no branches of trees or forest produce were in the seizure report, but all the statements made by the prosecution witnesses corroborates to each other, including the seized dhow, which makes it crystal clear that the 5 accused were cleaning jungles, perhaps with the intent to encroach the forest land. However, the seized items were not sent to the FSL does not affect effects into the case, as they were convicted of offense under section 29 of the wildlife destruction, etc. in sanctuary prohibited without a permit, which reads as follows, so and so, so and so. Now, my argument was that you cannot destroy a reserve forest without entering it. I cannot do some mischief in this court unless I enter it. So, to cut the jungle, to cut a tree, I have to go to the tree, I have to go to the jungle. There are 3 charges which were pressed against me in their complaint. Section 27, 29, and 39. 27 is unauthorized entry. 29 is destruction of the reserve forest. And 39 is sale in prohibited items, including livestock. 39 was dropped because they did not conduct the FSL test on the alleged deer leg. So the learned session judge dropped the charge itself. 27 was also dropped, Millets. Once 27 is not pressed against me, 29 mathematically cannot happen. Unless I'm firing some missile or something. So unless I enter into the forest, and it is also their case, they are saying that we entered into the forest, and the learned session judge says that we did not enter. So 29 goes on this ground alone. 29 cannot survive without 27 minutes. I can destroy the jungle, physically of course, only by entering the jungle. And I have not entered because no charge was pressed against me by the learned session judge under section 27 of the Wildlife Protection Act 1972. That is my first argument, and which has not even been dealt with, so admitted. So on this ground alone, Millets, I deserve to be, my appeal deserves to be allowed. Then Millets, they have not even denied, not even discussed that it is a cognizance of the offense is to be taken by the competent authority. Only then, the sanction is to be given by the competent authority, and only then the court can take cognizance. This has not been denied. No sanction was given by the competent authority, which is the chief conservator of forest and above. So on that ground also the prosecution is bad. Of course, that is a curable mistake. The want of sanction can be cured at a later stage because it is an administrative matter. Law is very clear. But for the time being, this conviction goes. Of course, my lords may, in my lord's discretion, may say that you take the sanction from the competent authority, and if sanction is given, you can start the prosecution. So law is clear on that. But so far as this conviction is concerned, Millis, the cognizance itself was bad in law because no sanction was given by the competent authority. That is my second argument, which again has not been denied. Now, third, my argument was, Millis, that in a complaint filed on 27th of May 2017, they have narrated the incidents of 29th of May, which is mathematically not possible.
Yes,
unless they are God or something. So being human, just like me and others, there is some manipulation. And in a criminal case, that becomes a very strong disability that if you are manipulating. And manipulation is made out otherwise, Millis, because complaint is to be filed to the judicial magistrate. It cannot be filed to the district magistrate. District magistrate does not have judicial functions as of now. Under the CRPC 1973 minutes, under the CRPC 1898, the district magistrate had judicial functions also. My lords must be knowing, in those days, my lords, ICS officer used to become, the judges, and they used to rise up to the high courts also. So, my lords, that with 1973 CRPC, that has stopped. So while on the administrative side, they may give their complaint to judicial district magistrate. They gave their complaint to district magistrate, not to the court. The court or judicial magistrate. And that's why complaint must have been filed on 29th only. And the junior officers of the department, they might have narrated the incident of 29th because it was 29th when complaint was being filed. So that has also not been denied or disputed. So on that ground also. And then I pointed out specifically the contradiction between the examination in chief of their witnesses. Apart from the fact, that they have no independent witness. They cannot seek concession from the court, because they are not able to enlist independent witnesses. That is their problem. They have to prove the charge against me. I am presumed innocent. They cannot say that in forest, how do we find independent witness? Well, this is not the way things are done. Where there is no likelihood of independent witnesses, witnesses are taken. Witnesses are taken. Central agencies are doing this. The CBI, the income tax, the custom, they take some people, just catch hold of some public sector, some bank, something, that we are going to conduct an operation, please be witness. And that is perfectly all right, because they are not being told what is the operation, against whom is the operation. So somebody is requested that we are going to conduct an operation, please be witness. And those witnesses are examined and put to cross-examination. So they cannot say, because they had enough time to organize a raid, to organize a police party, they could have organized 2 independent witnesses also. So to say that it is in jungle, you can't find independent witnesses, that's why the forest department official should be. Now the complainant is also becoming the witness. Obviously, he will support himself. So he cannot be a reliable witness, Mills. And then there are positive contradiction between, which I have pointed out to my lords. There is positive contradiction between the examination chief of the police witnesses and then forest department witnesses. The police witnesses have specifically said that they did not find anybody cutting any tree. They said that people were sitting on the ground, while the forest witnesses are saying that they were cutting the tree. So this contradiction of the prosecution witnesses itself is sufficient in a criminal case, Millets, to give the benefit of doubt. So You want to take time? Yes. Time when I, yeah. Time when I have to. Wait. You don't want time. Wait. So, let's, my appeal is under section 374 of the CRPC minutes. And the sequence of event is also completely unreliable, which again has not been denied or disputed or rebutted. Secret information is received at 6:30 p.m. The source of a public servant cannot be asked. Evidence Act is clear. I'm not asking this, but I'm asking who decided to conduct the search, conduct the raid? Somebody has to take a decision. That has not been disclosed. That person has not been examined, because that will give a complete sequence of events. A beat officer is not competent, Millers. They have not enclosed any document to support that a beat officer is permitted under the Forest Act or the Wildlife Protection Act to decide to take the decision to conduct a raid. It is done minimum at the Assistant Conservator of Forest, which is a class 1 post. Beat officer is a junior class 3 post. So, Millets, somebody must have taken this. They have not disclosed, not examined anybody that which senior officer was informed about the information received, because no information was received. Then, Millets, after the information is received at 6:30 a.m. Millets, on the first page of this written argument, Millets, second paragraph from the top, that on 27/5/2017 at about 6:30 a.m., a secret information was received by Sri so-and-so, Forest Beat Officer so-and-so, regarding illegal entry by some persons into Dol-Doli Reserve Forest and destruction of wildlife habitat. Information must have been recorded in some register. There has to be. Like in a police station, there is an FIR register or a general diary. So in the Forest Department also, there is a register prescribed in which all such informations are recorded in real time. As soon as information is received, they may not disclose the source. That agreed. Evidence Act protects them that they will not disclose their source. But they will say that a secret information has been received that at such and such place, people, if known name, if not known unknown persons, are destroying the forest. They have not exhibited that also, because there was no entry in the register, Millets. Then, Millets, the patrolling party reached, last para on the first page, Millets, at about 7:30 a.m., the patrolling party reached near FD pillar number 5 and 6 and saw 5 persons illegally cutting and clearing the jungle. Then on being confronted, these persons failed to show the entry permit, Millets. Millets, the police witnesses have denied this, that they didn't saw anybody cutting any tree. Now, police witnesses are more reliable because they are not part of the Forest Department. They are only there to protect the people. They are not there to. So, police witnesses will carry more credibility than the Forest Department officials who are the complainant, Millets. So, this is contradicted, Millets. Now, on the next page, Millets, they have quoted the definitions which I have already quoted, that rule number 2 within bracket small h of Assam Wildlife Protection Rules. Protected area means a national park. I have no quarrel with that. Then 12 capital of the Wildlife Protection Act, a forest officer means a forest officer appointed under so-and-so. Here I have a beat officer is not a forest officer. He is a forester, but is not a forest officer. Forest officer is minimum class 2. That is the range officer, which is appointed by the state government through normally Public Service Commission exams. So this goes again in my favor. Then as per section 2 of within bracket 2 of the Forest Act, forest officers mean any person state government appoints. They have not enclosed any evidence, Millets, neither examined in the court nor brought before this honorable court, Millets, to show that beat officer, which is a junior class 3 post, is a forest officer. They should have enclosed their notification. Then I would have probably, so since they have not enclosed, they are just making a bland officer, that beat officer is also a forest officer. You have to show the notification or the rule somewhere which says, so nothing has been brought. So Millets, this has also no force. Then Millets,
Next, my lord, according to Rule 6(9) of the Assam Wildlife Protection Rules, last para, my lords, cognizance of offences. The following officers shall be authorized to make complaint under Section 55, which includes any forest officer not below the rank of forester or any other officer authorized by the state government for this purpose. Here, beat officer is not included, my lords. Beat officer can only file if he is authorized by the senior officer. So no such authorization has been exhibited or led in evidence before the trial court, nor before this honorable court, my lords. So that also goes. Now they are saying in the seizure list, there are details of the items seized from the accused persons, which includes a dhow, deer leg, and a horn of white buffalo, which was seized by Sri so-and-so, which was witnessed by 2 eyewitnesses. Well, now they are contradicting. They are saying there is no eyewitnesses entire trial. Here, perhaps it is a typographical error or typing mistake. There are no eyewitnesses. That is their admitted position. Now they are saying that 2 eyewitnesses, but in that case, those eyewitnesses should have examined. Since you have not examined those eyewitnesses, you cannot take shelter of them. So this also goes, millets. Now they are saying, now for examining independent witnesses, the Honorable Session Court has already observed that no independent witnesses can ordinarily be available for as entry into such forest itself is prohibited by law. Agreed, millets. But you are prosecution, you are a state. You are proposing to take away my life and liberty. You have to comply with the requirement of law. Arrange, the way you arrange police protection, you could have arranged witnesses also. You could have taken them. Law permits that. All other agencies are doing this. So they cannot take the shelter. And that's why I am before my lords that Honorable Session Court has fallen in error in saying that since you cannot find independent witness in the reserve forest, that requirement will be dispensed with. That cannot be dispensed with. That is because it concerns the life and liberties. Article 21 and Article 14 are there to protect a citizen for this. So let's next para. The Honorable Session Court has further observed that the Forest Department officials are the most natural witness in such cases because of their experience and knowledge of terrain. They can be treated as expert to determine whether the place fell on Assam side of the border or not. Further, all the PWs corroborated to their statement that the crime scene was between the 5th and the 6th border pillar on the Assam side of the forest reserve. Further, it is to be mentioned here that the witnesses of the forest department corroborated one another and that these accused were cleaning jungle, perhaps with an intent to encroach the forest land at the time of their apprehension, and the defense has not been able to shake them in the cross-examination, millets. This is exactly where the learned session judge has fallen in error, millets. They may be expert witness for any issue arising under the Forest Act, not under the CRPC. A forest department official may be expert because he has domain knowledge, terrain knowledge regarding the forest produce, regarding the flora, fauna, all these things. He can identify a particular tree, that whether it is a, scheduled tree or not, but he does not become witness of a crime, an expert witness of a crime. There is no concept of expert witness of crime under the Evidence Act, minutes. Section 45 of the Evidence Act is very clear that there shall be expert witness who are domain witness, because court is not expert of domain. Court only knows the law. Court, like, that's why doctors are examined in certain homicidal offenses, because court or the advocates are not the experts of human pathology, human biology. So those who are expert are brought in, but they are not experts of CRPC. For that, court is there, advocates are there. So this is the error in which it has learned session judge has fallen, millets. So this also goes in my favor. Now, millets, next point is, now whether the accused persons were cutting and clearing the jungle, the answer is positive, as although no branches of tree or forest produce were in the seized report, but all the statements made by, I have already read it, millets. So, millets, if they have not seized or they have not found, they have not seized because they have not found. If they found me cutting the trees, they should have taken those branches also. They have taken all other things. Those branches could have been, because ultimately those branches would have dried up, but the wood have been identified, because wood can be identified and their domain expertise can be of help. Nothing was seized because nothing was cut. And this is in the teeth of the deposition of the police personnel. Second, my lord, the whole story falls because they have not disclosed who gave them police team from the district police superintendent's office. Normally, police protection can be provided either by the SHO or by the district superintendent of police. So somebody from the forest department millets must have contacted the police officers, either the office of the district superintendent of police or the SHO concerned, because no other officer in the district is permitted to deploy the police personnel. Deployment takes place either at the Thana level, my lords knows it, or in the office of that superintendent of police. So they are not disclosing, they are not examining, they are not exhibiting any request made because no police protection might have been sought. Now police personnel are saying that they were on routine patrolling. That goes against them. They were just on routine patrolling. Then, my lord, which is the most serious is, under the Assam amendment to the Wildlife Protection Act, copy I have placed on the records of the court, it is not a non-cognizable offense. Millets, it is made cognizable. Once it is made cognizable, millets, and there is a police party with them, why the local SHO was not informed? Both the forest department officials as well as the police party had an obligation to inform the territorial magistrate or the territorial SHO about commission of a cognizable offense. Only an investigation would have commenced under section 56(3) of the CRPC. The police personnel themselves would have reported the matter and SHO would have filed an FIR under section 157 of the CRPC. There is no report given to police station. Why? It's a cognizable offense, millets. And there is a police team with them. Because nothing was happened. They were sitting on the Nagaland side in their own land. Now, millets, we have enclosed in our appeal memo also. They all are landowners. Land have been allotted to them by the panchayat. And on page 11, millets, we have attached the pattas of the land given by them. They were working in their land. Page 11 of the appeal minutes. Appeal memo. So, millets, page 11 of appeal memo, millets. I'm sorry.
Yes.
Millets, gone to the plot of land, I'm reading from the top, belonging to one of the appellant number 5, so and so, whose land is located in Nagaland area near Assam border, Lahori Jan side, and proper land title and registration has been issued by the state government as well as by the government authorized village panchayat, issued at Rilan Village Council, village patta number 179, issued on 6/7/2014, copy enclosed. We exhibited this before the learned trial court. My land is there. I am working in my land along with some more persons of my village, laborers and all. So, just because I am present on the border, that doesn't mean that I am cutting the reserve forest. Well, except the cutting the tree, all other allegations were rejected by the learned session judge itself. The section 39 charges were dropped. Section 27 was dropped. That means nothing. I did not enter into reserve forest and I did not have any prohibited meat on me. That is the deer leg and wild buffalo horn. So, millets, once I'm a valid patta holder, there is every probability that I was confronted in my land and thereafter all this, and that's why so much mistakes have taken place. So, millets, since this court, millets, the law is very clear and appeal court under section 374 CRPC, millets, have all the power to appraise the entire evidence once again. So, my lords have complete jurisdiction to reconsider the evidence and arrive at a judicial conclusion. So, I am saying, millets, that the finding returned by the learned session judge that I was destroying the reserve forest for which I have been convicted is not supported by the order of charge itself, number one. It is not supported by the independent the constraints, the independent witnesses and treating police witnesses as independent witnesses because they are not under the control of the forest department. They have not supported. I have shown to Millets their the contradiction between their examination in chief and the examination in chief of the forest officials. So Millets, taking into totality, it is a case where learned session judge has fallen in error in convicting the appellants. And I pray to my lords to exonerate them in the interest of justice.
Any other submission?
My argument is already before your lordship.
Please approve.
Should I give a short synopsis, complete, just page number and para, etc. If it is
can
convenient to the court,
otherwise-
just for reference, that will be, I mean, because records are a little bulky.
You can.
Within a week, minutes.
Yes, better to give within a week.
Within a week, within 1 week, my associate will submit. Obliged.
You're leaving today itself?
Maybe I will have to stop because one matter is tomorrow. So client is now making he's just pressing me that please stay back. But I have another matter in anticipatory bail in Delhi High Court. So both set of juniors are quarreling. Let me see. Much obliged, minutes. I'm grateful.
Submit it within 1 week. Yeah, already. It might hold up that he will take it and keep on.
21.
This is the last. 21.
With your lordship, there is a delay of 570 days. Your lordship, it's a jail appeal. Convicted under section 376 1 and 306.
No, 21. In 21, we don't have anything. 21, we should do that.
One is for suspension of sentence. This is for suspension. I 10287. This has not been numbered. So all filing numbers. Appeal, jail appeal, and I. This is for
In limitation is this one. So you are on 1075 is for limitation.
Yes, yes.
How many? What was the delay?
570 days.
570 days.
Just
Where you have explained your delay?
15 to 23. Judgment was delivered.
Your delay is explained in which para?
My delay is explained in your lordship in paragraph 2. Paragraph 2 of my IA.
So, what documents you have to receive from Legal Services Authority?
They have only furnished a judgment copy only, and all the relevant documents, the PWs and all the relevant documents, and FR has not been enclosed, your lordship. So there is a delay of 570 days. From the legal.
Is it the duty of the legal, the Legal Services Authority?
Yes, yes. The Legal Service Authority has itself received a copy on 23/7/24, which has been enclosed.
No, here the Legal Aid Council was engaged.
Yes, sir. I'm the Legal Aid Counsel.
Here they are also your Legal Aid Council.
Yes, sir.
Okay. Yes, Goswami. Do you have any objection? এই কেইবাটাও আছে তাতে এতিয়া এটা খালি হ'ব 1075 আৰু ক্ৰিমিনেল যে এপিল যেটো আছে 10286 it is a filing number. Hardemus S. Khatunian, Tilanet, you are legal aid counsel.
Yes,
It's
sir.
not reflected here. Legal aid counsel for the petitioner and applicant, and also heard Mr. MP Goswami. The learned additional PP appearing on behalf of state respondent. And this is an application under section 5 of the Limitation Act, paying to for condonation of delay of 570 days in preferring the connected criminal jail appeal. It is submitted by Mrs. Khatunian. You are Khatunian, no?
Yes, sir.
Khatunian, the delay was, there was a delay of 570 days in preferring the appeal as the copy of the judgment and some relevant documents. No, as some relevant documents were not furnished by the Legal Services Authority to the council for preparing the appeal, though the copy of the judgment was furnished to the council, legal aid council. This full stop. The judgment was delivered on 15/2/2023, and the learned council learned council had received the copy of the judgment and order on 23/7/2024, but no other relevant documents were furnished to prepare the appeal. There is no negligence or laches on the part of the appellant, and it is only because of non-receipt of the relevant copies from the authority concerned, the appeal could not be preferred within the stipulated period of time limitation. Accordingly, he prayed for condoning delay of 570 days in preferring the appeal. Next one, Mr. Goswami, learned additional PP, raised no objection and submitted Mr. Statutory appeal, and he has no objection if the appeal is if the appeal is numbered and registered, condoning the delay of so and so. Allow for it. Okay, petitions. Raised is ever directed to number 41, raised. মেট্রোটা উঠেছিল সিবিআই নাইকার নাকোজে বেশি এরকম
item 18.
item 18 মাথা ভালো লাগে
Before that, there's one time limit.
আমি তো জানি 15 item 15 is also time limit. মাথা ফুটো মাথা নাহলে এটুকু একটা বেশি বেটার হবে কি এখন আর কাম নেই
Timing 80.
Statutory appeal for 3 years.
Statutory
probation.
appeal
And he is on previous bail, and moreover, he is aged about 80 years. That is it. So it may be allowed to remain on previous bail. That is the normal train of this court.
Lordship will file an objection. Lordship, can you give me some time?
Why objection? Why are we
Provision says
3 years? Already he is on bail.
I understand. But provision
That of
says-
why on bail you are giving him?
Provision
Appeal he
says-
can give objection.
Appeal, no.
Because
There
tomorrow is
there-
the date in the trial court.
We extend
He
it.
is even allowed.
Extend it.
Unnecessary it will keep pending.
I leave up to you.
Because
Lordship,
3
because
years.
there is a provision for,
No, not for 3 years. For when it is life, their objection must be there.
and read it.
Not in 3 years, Lordship. Not in 3 years. For life it
we
is
had
there.
that the interpretation what is this say the interpretation is a bit different in the section says, though we are saying
Not in PCA, not in PCA Lordship. This is PCA case, though he has been convicted under IPC, actually
IPC
cases are
offences are
severe.
Huh?
IPC.
But that
offences are
objection
there.
it will not come.
Where is the offences, Lordship?
When he is allowed to remain on previous, if he is in
Punishment is
jail, then it's different thing. They can file objection. That is the normal train. Above 3 years, Lordship will consider after, suppose he is inside, then his case is different. But now he is on previous bail. And he is a person of 82 years. And trial commenced in the year 1999, charge was framed, now conviction has taken place. So more than 25 years, trial has taken place. That particular Lordship will consider. And lot of cases Lordship will find that when the conviction up to 3 years, normally allowed to remain on previous. That is the train of this court. That's why I pray before Lordship.
$413 million.
It's a new.
BNSS.
Yes. 430, no? Suspend of sentence.
413.
No. 438.
430.
430.
430, 430.
May kindly see the proviso part note. Second proviso. First proviso, let us read first. Provided the appellate court shall, before releasing on his own bond or bail bond, a convicted person who is convicted of an offence punishable with death or imprisonment of life, or imprisonment for a term not less than 10 years, shall be given opportunity to public to show cause in writing against such release.
That's why 10 years life and death objection is mandatory.
Correct.
Not in case of 3 years. That's what I am submitting.
No. Convicted an offence. What is the offence here?
Offense punishment is 420. You have to see the punishment.
Yes, correct.
Where dates,
Correct.
then life,
Correct.
then up 10 years.
Correct.
Here it is 3 years.
Let us see what are the offences under which he has been punished.
420,
467 is there.
467 and
Now
471.
let us read 467.
No, conviction. You'll have to see the conviction, not what the offense,
Conviction
how much
of
it is,
the
can be
offence.
convicted.
Language is conviction of the offence.
Conviction is 3 years now.
Conviction of
Conviction is
offence
what?
punishable with death.
Now, Mr. Halloy, on that day also there was a submission from Mr. Halloy. And the question is that 3 years, obviously 3 years,
3 years.
not on dispute that. But he is saying that what is the section? What is the the section? If the section is the penal provision is up to death, imprisonment for life, in that case, public prosecutor may be.
When he will be convicted for 10 or life, then objection will be.
Convicted
Then
is
the-
not there.
That will also mean.
Just see the line.
Because in a division bench, that's why they have filed an objection.
Who is convicted of an offence?
Convicted. I am convicted for
an offence.
Offense. Punishment is important.
Convicted of an offence punishable. You just see the line. Just
Lots of
read.
kindly see. 430. The 2 is that the appellate court shall then send for record so and so. If any appeal is only to extend on legal sentence, the court may decide appeal without sending for a record. Where, 430. 430. Provided the power conferred by this section on an appellate court may be exercised also by the High Court in case of an appeal by a convicted person to a subordinate court thereto. Where the convicted person satisfies the court by which he is convicted that he intends to present an appeal, the court shall, where such person shall being on appeal, being on bail or sentence imprisoned for a time not exceeding 3 years. Where the offence of which such person has been convicted is a bailable one. Here you also will kindly see. 433 you also will kindly see. Where the convicted person satisfies the court by which he is convicted, he intends to present an appeal, the court shall, this is for a trial court.
Trial court.
Trial court. When appellate
430.
High Court may issue warrant. High Court appellate.
430.
430 to more for it to support 430.
430 to go.
No, provided appellate court shall, before releasing on his own bond or his bail bond convicted person who is convicted of offence punishable with death or imprisonment. Where the punishable is death, conviction is death or life. Then for a term for not less than 10 years, shall give opposition public for showing cause in writing against such release. Provided for that in cases where a convicted person is released on bail, it shall be opened to the public to file an application for cancellation. That is defined part. So here, punishable with offence punishable with death or imprisonment for life. Or imprisonment for term not less than 10 years. Shall be give opposition showing cause in writing against such release. That particular now conviction is for 3 years.
I mean, there is this, the word confusion is,
So
a
there is
little bit
confusion is
there, but the question is then offence punishable with. Not,
correct.
it's not that, not
But
conviction.
now I have been punished for 3 years.
Yes,
That's-
you're convicted for 3 years,
3 years.
but the offense
Definitely,
punishable.
definitely.
That is the difference. Anyway, we're extending your thing
That,
that
lots
will
of
be
that I have
extended.
to
In the meantime, you find. Because
Because
if he has
otherwise,
some
he's
objection.
3 years old unnecessarily.
Okay.
In trouble.
Your date is fixed tomorrow.
Tomorrow.
You click on I 1153. For Mr. D. Director, for the petition. Why it is written as retainer counsel means?
Where
Tomorrow, retainer counsel.
retainer counsel.
Retainer counsel.
CBI used to give appointment as retainer counsel, come special keeping.
Earlier,
It was
this
standing
word
counsel.
retainer counsel was not there. Now it is retainer counsel.
My appointment is as.
So what to
special-
write? Retainer
any-
counsel?
Anyone, Lordship, you can write special PP also, retainer counsel.
Also
Either
heard special
standing
PP,
counsel was, sir.
CBI, Mr. M. Hello. When so?
No, 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 it's cause this of the.
This is an application under section 430 BNSS for suspension of sentence and realization of fine for the releasing the accused applicant on bail. Short photo, it is submitted by Mr. Talukdar that the accused petitioner was convicted. Under which section you are convicted?
He has been convicted.
Under section
Under
120B.
120B, 420, 467, 468.
471
470.
IPC and sentenced him to undergo 3 years rigorous imprisonment on each count under section 420, 468, 471 IPC and to pay fine of rupees 10,000 on each count. In default, further arrive for 4 months
Clarification I would
on
like
each
to
count.
make. One clarification is that prior to that in 431 year also will kindly see, pending any appeal by convicted person, the appellate court may for reasons to be recorded in writing order that the execution sentence or order appeal against be suspended. And also if he is in confinement that he be released on bail. If he is in confinement, that is there. Here I am not in confinement.
No,
You have
it's
been
okay.
granted temporary bail to prepare an appeal.
But I am not in confinement. That's what I.
You are not on confinement.
Got it.
Confinement is also there. That is earlier it was 489 suspension.
That-
Sentence
that-
was also there, releasing them on bail. But it is
My
you are on
concern, when I am in confinement, then this proviso will get tracked. That I am trying to say.
Oh, no,
Hey,
I don't
one.
think so. Don't think so.
Okay,
Anyway,
I'll leave it to us.
NRI for 4 months on each count, huh? And the accused was also sentenced to undergo RI for 2 years for section 471 IPC. In default, RI for 4 months. RI for 4 months. Mr. Talukdar accordingly submitted that the accused petitioner is accused appellant is still on previous bail and accordingly paid for extending his previous bail till disposal of the connected appeal and also to pay for suspension of sentence.
Already confinement.
Next part. Mr.
Halloy.
Come submitted in this regard that the respondent will file the written objection. Written objection against the present petition.
No, one more than like it.
In that context, Mr. Talukdar further submitted that the accused appellant is 82 years of age and the tomorrow is the date fixed by the learned 82 years of the age and tomorrow is the date fixed by the learned trial court. Consider expert.
Release on bail. কিন্তু ঠিকই আছে। If he release on bail, কিন্তু there is a provision.
Against be suspended.
Considering the submission made by the learned also for both sides, the accused appellant is really the previous bail of the accused appellant is hereby extended till next date of listing. However, the order on regarding the suspension of sentence will be heard on the next date of listing after filing the objection by the learned, special PP on behalf of respondent. So next date of listing, your previous bail is I have extended. You
And
can make
appeal
that
is
change.
admitted.
Appeal can be admitted. Appeal admitted for you. We are admitting appeal. Call for the LCR is there?
Lordship.
Call for the LCR. Is there any other private respondent also there?
No, CBI.
No, other private also.
Other private,
Oh,
about
Aste.
5 accused has been convicted.
Not in this case.
Not in this case, in the judgment, in this judgment.
In
There
the
are respondents are not there, only he is.
No, only respondent.
Respondent
state
is
only
the CBI is the only.
CBI.
Because informant is the CBI.
We will,
Fix after.
you tell us, because we have extended.
Because you will have to file.
Let it be after vacation.
After vacation,
Let it
list
be
after
after.
vacation. Okay.
Hello.
Yeah, please, your lordship.
She was not there. I think she was getting card. Now, who is the other side? State is there?
Yes, state is there.
Okay. Yes.
Yeah, please, your lordship. Lordship, this, the cause of action to file this revision petition starts from page number 16 to 18, your lordship. My specific grievance will reflect in page number 18, your lordship. Here, what happened, your lordship? The session judge of Sipsagar, your lordship, passed an order, your lordship, allowing Jimma, your lordship, of my vehicle, subject to a condition, your lordship, furnishing of a subject to furnishing of a bank guarantee amounting rupees 3 lakhs, your lordship.
And
That
this,
is-
just a second, this comes under this cattle provision act.
Lordship.
I must say one thing to you.
Lordship.
Here, my view is a bit different. Maybe different from the other benches and all. So I think that you may not get. That is, I'm just clearly saying. Because there's a specific provision in the act itself. So they're violating the provision, that provision on this.
You see, the cattle preservation act is there, your lordship.
Yes.
Provision is there, your lordship.
Provision is clear there.
But
But
otherwise,
how can I say that appropriate bench? That is also a difficult in my part.
but otherwise, lordship, with due respect, your lordship, the plethora judgment of this honorable court, your lordship, with the provision, the condition has been relaxed, your lordship. I have 3 judgments.
Yes, I have.
Yes,
I know.
yes, yes,
There are
yes,
judgments.
lordship.
That is not disputed. Yes. What can we do? What can we do? Itu মানে মই দিব বিচৰা নাই। Because he suggested me that we may pass an order the list after 1 week by mentioning if it can be.
Otherwise, your lordship, if your lordship permits, I'm adjourning the matter, your lordship, for next week, your lordship, then.
No, just that's what I'm telling.
Yes, yes.
I'll be matter may be listed after 1 week.
Lordship.
Just I'll tweak that order only.
Lordship.
And by making mention before the registry, you may make
Lordship.
that.
Lordship.
Because otherwise 2-3 judgments I have already delivered.
I have
It
also.
may hurry. So I'm
Lordship.
okay. List after 1 week. I just passing list after 1 week. So
Much obliged, lordship. For orders, item 28.
This is an appeal by the NCB for acquittal of the which persons.
Acquitted.
We file application for seeking leave. This case is listed for a loss. They were acquitted that there is a violation of section 52A.
Peter to issue notice, I think.
Not
Heard Mr. S. C. Kyle, the learned counsel for the petitioner and applicant. Appellant. No, it will be Applicant, appellant. Huh? That's what, this is an application under 419, subsection 3 of the BNSS. Against the order of acquittal passed by judgment and order dated 23/07/2024 by Larned's Additional Session Judge number 2, Kamrup M, Guwahati, in NDPS case number 68 of 2013, arising out of NCB crime, case number 06 of 2013. Issue notice query. There are two respondents.
Okay.
Two respondents
Yes,
are there.
two respondents.
Issue notice to the respondents. Petitioner will take steps accordingly. Listing matter after 4 weeks. We are listing it after 4 weeks. Issue notice.
We'll take a step by step process.
Yes, step by step.
Much good.
29.
Wait, please, Your Honor. This is an IA, my lord, for suspension of sentence. My lord, the applicant, my lord, was convicted under section 304B.
Suspension of sentence, the state has already filed their objection and it required. Have you filed or not yet? Otherwise, we have received the case record.
7 years.
It's a
Case
7
record
years.
is received.
Yes, case record received, my lord, 7 years punishment.
Then why fix it in for a hearing only then?
Because there is an office note, that is why it is fixed, my lord, that respondent has died, my lord. Dead.
No, on the last date, my lord.
Respondent died.
Yes. On 24/10, I have seen an office note, my lord, that it was of my lord, service. Respondent died, that is why it is answered.
But my lord, in 7 years,
24/10, 24.
since the sentence is of 7 years, my lord, on the earlier occasion, my lord, the honorable court said that presence of respondent number 2 is not required. And that's how, my lord, the matter was fixed for hearing on application for suspension of sentence, my lord. Small issue, my lord, hardly will take 10 minutes.
Otherwise, what was the case was under POXO or city 70?
304B.
304. The respond number 2 was the informant.
Yes.
Yes.
Yes, Gusami. Otherwise, you are ready?
Yes, my otherwise, no, I am thinking about this, my that is why I have not seen the LCR portion, my lord. So, but
You have to see the LCR.
yes, I have to see the LCR. But since I
No,
have seen
but otherwise, the LCR we have already received. Right?
received, my lord.
Can it be fixed for hearing? How, since when he is in custody?
Since January of this year.
January.
For hearing is very difficult, my lord, because it will come at the bottom, my lord. So ultimately, it will not reach. If I submit or
Kindly fix for hearing, my lord. If it is not fixed, my lord, then I can be taken up, my lord, in any date. My lord.
Otherwise, my lord,
I can be done, then 2 dates, 2 dates.
No, my lord, the same date, my lord, if hearing is not reached, my lord. If
then, my lord,
No, he is saying that if it is in hearing column, suppose it may not reach. That is. In that circumstance, I can be
I
hired.
can be, my lord, taken up for hearing, only the I. If
Priority basis.
Yes.
No, I'll take only 5 minutes, my lord. If I can complete my part, he will complete his part on the next date, my lord. I'll have
Part heard I want. Part heard because I'm here till next week. I don't know. My bench may not be here also. Part heard may not be.
The sentence is only on the basis of a dying declaration.
It's okay.
Yes.
If Gusami is ready, then we can hear. Otherwise,
Well,
part heard I won't.
Yes,
take.
yes. Then, my lord, it has to be within a day or two, my lord, if he completes his part, my lord. Then I can submit in Monday or
Monday, Tuesday.
No, I will try. Otherwise, my lord, I have to go to the record.
No. For hearing matter, already 24, 27 each day is fixed. No,
Yes.
it's not at all possible.
Let the IA be heard first, my lord.
Because of this part, my lord, I thought, my lord, the office note, since the respondent has died, perhaps there has to be my substituted. That part I have, but that is why I have done. Or my lord can take it up tomorrow, my lord, if Lordship wants.
That's what we are saying. From tomorrow to next Friday, there is no date at all. All the for 25 matters are fixed matters are there. We have already fixed. It's not possible. That's why. So let it be on hearing column until next day, then only it will reach. No, sorry, in order column.
Fine.
Order column it can be. Any request made by the learned additional PP, Mr. MP Goswami? Let the. So you want any reflection of the order of I mean, that of the
Yes,
number 2?
because this is a clear office note, my lord, because the notices were first issued by the court, my lord.
But that was office note was already observed, man, on the earlier occasion.
But it is
Although
not
it
in
may
the
not have been
record.
reflected in the order.
Where in the order?
My
Where
lord,
you're
It's
saying
not-
that?
Not
Yes.
reflected, man.
No, you're saying that.
Previous to the earlier order, then
Which one?
my lord, it will be on 28/10.
Here too, it is not there. That is still due process. That is in the due process. But here, it's not here. It's not here. Except it not stated here in, we have submitted.
Order.
Mostly, I have not seen any such kind of order. Anyway,
Order-
26 to, there was an order and
Order.
2003, your submission was there.
Yes,
That's for number 2 steps you have taken.
yes, 28/10, my lord, order.
28.
8/10. The office note was made, my lord, prior to this order, madam. On that day itself, my
I
lord.
don't know
Yes,
if
yes.
whether it was brought into
Yes,
the notice or knowledge of the court. I don't know. But interlocutory application, second you go, that much only. I have to
Yes,
say.
yes.
Anyway, heard Mr. So-and-so Koidigo. It is submitted by Mr. Goswami that as per the office note dated 24/10/2024. The respondent died, the notice returned unserved. That context, Mr. Das, the learned counsel for the applicant submitted that matter may be heard in absence of the respondent number 2 as the conviction is only for 7 years. Mr. Goswami, the learned additional PP, paid for an adjournment, submitting that he has not gone through the case record till date. This is the matter accordingly. You want any fixed date?
My lord, may
He
fix the
was
date, my lord.
Any date, my subject to your lordship's convenience, my lord. Short date.
Now see, these 2-3 weeks or 2 only weeks are there. And from since December 17, 18, 19, I mean, these things we do not want to be because all the other motion matter will be there. At that apart, we have some personal problem because both the private secretaries are from different states.
Then my lord will list it after 1 week, my lord, without mentioning anything.
Without one
Yes,
week.
After 1 week.
List after 1 week.
Yes.
Now, in order column itself, we are
Yes,
listing.
order column. Highly apply.
30.
May please, Lord. What did IA for suspension of sentence and for bail, Lordship?
Some sentence we are not
Yes,
going to hear.
Lordship may kindly see for a moment, Lordship. Lordship, there is nothing on record to even or remotely connect the present appellant to the offense, Lordship. And there, Lordship, there has filed the objection. Respondent number 2 has appeared, Lordship. And Lordship may kindly see. Only Lordship, not much time. I will not take that much of time, Lordship. With Lordship's permission, I would like to place this compilation, Lordship. Lordship, may I kindly first take up the appeal memo, Lordship.
Hearing আহিব লাগে এইবোৰ বহুত টাইম গুচি যায় আকৌ এনেই গুচি যায় দুবাৰ কৰি থাকিব
Appeal memo, Lordship.
A 10 years punishment, my lord.
Lordship is found, appeal memo. Memo of appeal, Lordship.
Which page?
Memo of appeal, page number 26, judgment, first page. 26. Lordship is found it. The accused, Lordship, 4 numbers of accused are there, Lordship. And the appellant's, Lordship, accused numbers 2 and 3. And 3 of them have been convicted. 1, 2, 3. 4 has been acquitted. 2 and 3 are behind before your Lordship. And Lordship, then Lordship may kindly see page number 28. Page number 28, Lordship. All of them have been convicted under section 370 IPC. And sentenced to undergo simple imprisonment for 10 years, not RISI. Then Lordship, page 28. Lordship, serial number 1, accused details. Shyam Lakwa alias Paglu is the applicant number 1. And Lordship, he was charged with, Lordship will find offenses charged with. In the column, accused Sri Shyam Lakwa alias Paglu is charged under section 363 IPC. And Lordship, thereafter, Lordship may can receive serial number 3, pin 230. Applicant number 2, pin 230 on third serial number. He has been, Lordship, accused persons, namely, then offenses charged with. Accused person, namely, Kesar Praja, alias Shekhar, and Sri Pintu are charged under section 370 IPC, read with section 14 of the Child Labor Prohibition and Regulation Act. Lordship, what happened, Lordship? All 3 have been convicted under section 370. When the accused number 1, that is the applicant number 1 herein, Shyam Lakwar, was charged with under section 363 IPC, he has been convicted under section 370.
But charges frame under which section?
363. So he cannot be convicted for a major offense without their alteration of charge, Lordship. Then Lordship may kindly see sentences imposed. Dear Lordship, sentences imposed. Lordship has got it. Sentences imposed. Applicant number 1 was charged under section 363 IPC, but convicted under section 370 IPC, without there being any alteration of charge. But accused applicant number 2, Pintu, that he was initially charged with 370 and subsequently convicted under 370. So for him, the alteration is not required. But for applicant number 1, without there being any alteration, he was convicted under section 370. Then Lordship may kindly see sentences imposed. Accused persons, namely, Shyam Lakhwa alias Paglu, applicant number 1, Lordship. Then Sri Kesar Poja, he is not before your Lordship. Then number 3, Pintu Tati, applicant number 2, are sentenced to minimum prescribed punishment of 10 years and to pay a fine of rupees 10,000 under section 370 IPC. In default to SI for another 6 months. This is the Lordship sentence. All the 3 accused persons have been convicted under section 370 and sentenced to SI for 10 years. This is not RI, it is SI. Simple imprisonment with default stipulation with fine, Lordship. Then Lordship may kindly come to page number 43, the part of judgment, Lordship. Lordship may kindly see list of prosecution, defense, court witnesses. Lordship has found it. Page 43. There are, Lordship, 3 numbers of witnesses mentioned. PW1 Srimati Jaimati Tati, the informant. The respondent number 2, Lordship. PW2 Srimati Chanmani Tati, she is the one of the alleged victim. PW3 Miss Lakshmi Homis. These three are the prosecuting witness, neither the IO nor the MI nor any. 6 witnesses are cited in the charge sheet. 6, including the IO and MO. Six with PWs are cited in the charge sheet. And Lordship, only 3 examined, informant and 2 alleged victims. IO not examined, and Lordship, MO not examined, another witness not examined. Then Lordship may kindly see the next page, page 44. Page 44, Lordship. Lordship may kindly see the exhibit. List of prosecution, defense, court exhibit. Only one document was exhibited. That is, Lordship, PW3 exhibited, exhibit P1, which is the statement of the victim under section 164 CRPC. This is the exhibited document. No FIR was exhibited, no charge sheet was exhibited, only statement of the victim under section 164 CRPC. FIR not exhibited, charge sheet not exhibited. One single document was exhibited. Then, Lordship, there is no defense exhibit, nothing. Only exhibited, only document exhibited by the prosecution is the statement of the victim under section 164 CRPC. FIR charge sheet not exhibited. Then, Lordship may kindly come to page number, Lordship, 19. That, Lordship, is the deposition of the informant. Very important, Lordship. Page number 19. May I read, Lordship? I am the informant of this case. I do not know the accused persons. Incident took place last year during winter season. On the day of incident, I, along with my younger sister Chanmani and Lakshmi, who were the alleged victims, went to Samlang T Estate number 8 line to my father-in-law house. I sent my sister and Lakshmi to our house with my brother-in-law, but she did not return to our house. We searched her everywhere, but we could not find her. But having no alternative, I lodged an ejaha in Dumduma PS. Later on, Dumduma police recovered my sister and another girl from Arunachal Pradesh. Later on, I came to know that one person, namely Shekhar, took them to Arunachal Pradesh to work somewhere. There is no whisper about our role, Lordship. Then cross is very important, Lordship. I do not know the contents of Ezahar. I do not know the name of person who scribed the Ezahar for me. Due to misunderstanding of the fact, I lost the instant case. As narrated in the Ezahar, no such incident happened ever with the victims. I have no objection if the case has been dropped against the accused person. This is the informant deposed before the learned court below, Lordship. Then, Lordship, page number 21, PW2. PW2, Lordship. She is the sister of the informant. Lordship, got it? I know the informant of this case as she is my sister. Last year, I, along with Lakshmi, went to Arunachal Pradesh to work there. One person, namely Shekhar, took us there. Shekhar is not before your Lordship. After staying 10 days there, Shekhar brought us to Dumduma PS. We went there without informing our parents and relatives. Now I am staying with my parents at home. Police recorded my statement and escorted me to court for recording my statement under section 164 CRPC. In my statement, I put my thumb impression. Then, Lordship, page next page, cross-examination. No any incident or bad act happened with me. No one forced me or for any type of child work, as well as no one abducted me from one place to another place. My sister, who is the informant of this case, lost the instant case due to misunderstanding of the fact. As I, along with another victim, did not inform to our parents about our departure for work, as such, the instant case was lost by my sister. None of the accused committed any such act as alleged in the case record. Today, whatsoever I depose in my examination in chief, stated before the magistrate under section 164 CRPC statement, the concerned magistrate did not read over the contents of my 164 CRPC statement. I have no objection if the case has been dropped against the accused person. This is, Lordship, one of the alleged victim. Then, Lordship, there are PW3. And apart from this lordship, there is nothing, no more witnesses examined. And on the lordship, prayer of the learned PP, the prosecution evidence was closed. And the lordship will get it from the comparison I have given lordship.
Sorry to interrupt, my lord. My lord, my learned friend is going for the appeal, my lord. Now the prime consideration is they come up for orders, my lord. Now the honorable court has to see, my lord, whether there is any ground prima facie, whether any evidence is there for his conviction. But there, that appeal part is there, my lord. There it will be, my lord, decided, my lord, whether that prima facie or lordship has to satisfy that he will not be, my lord, convicted, my lord. He will liable to be acquitted, my lord. That part your lordship has to make the satisfaction, my lord. And
That lordship I have submitted.
Cannot, my lord, at this, my lord, what the honorable Supreme Court has said, my appellate court, my lord. A lordship has to see, my lord, a lordship cannot, my lord, re-appreciate all the evidences.
That's what he
that
re-appreciating all.
Yes, because your lordship, now your lordship is not sitting on appeal, my lord. Yes, lordship can, my lord, re-appreciate, that is under appeal, my lord. Now he has come up for bail, my lord. Only the purpose of bail and suspension of sentence, my lord.
But
So
for the
it's-
purpose of bail.
For that has to be linked, my lord.
Apart from
let's
evidence,
take-
what are the other
let's-
issues? we
Because
have?
your lordship,
Yes.
what I am seeing, my lord. Lordship, he has rendered the PW 1 and 2. PW 3 just only lordship may kindly read the PW 3, my lord.
Yes,
But your lordship-
I can read lordship.
what
PWC
your
I can
lordship-
read.
PW 3 is very much, my lord, he is pointed out to this petitioner that this petitioner has taken those victims, my lord, statement of the victims, my lord.
Lordship,
He has taken away those
he may reply
Yeah.
lordship. First, let me complete lordship.
So-
PWC,
so
I have
just-
PWC, I
then,
have.
the
setting the
question is
record.
that
You cannot
every
take the whole day.
PWC
No, I'm not
if
taking, I'm
you
going to take the whole day.
Because
PWC,
I
there are
cannot
other-
appreciate every evidence
Lordship,
here in
lordship.
this. That is why, that's why otherwise.
Yes, my friend. That is their lordship. PW3 lordship, what I am submitting is that only on the basis of PW3, discarding the other evidence, can they be convicted. That too, the applicant number 1, without there being any alteration of charge. He was facing a trial under section 363, which is a minor offense lordship. Punishment lordship is a bailable offense lordship. But he has been convicted to under section 370 IPC lordship.
Both the matters could
Yes, lordship, I want to
be
rely
hard
on.
together, at least the
Lordship.
appeal and all.
I want to lordship place. Lordship, I want to place on record one judgment law, Honorable Supreme Court.
Otherwise, everything, if every
No lordship, because
judgment is to be
because when it is
appreciated, then it
apparent lordship, it's palpable lordship. Because I am not asking you this honorable court to reappreciate all the evidence. Because neither the FIR was exhibited, nor charge sheet was exhibited, nor the IO was examined. The IO is not examined. I've been prejudiced because I could not bring the contradiction lordship. That is vital right, lordship. Lordship may
That
can
is
see
what
this
I say,
judgment.
na. He has good grounds of appeal, my lord. That is
But
why-
they are behind the bar, lordship. That is
But
what my anxiety is.
That grounds, only the grounds, my lord,
No.
what is decided. But that will not be, it will, whether at this stage, my lord.
Lordship may kindly see para 33. This is the judgment of the Honorable Supreme Court. Para 33, lordship. Para 33, lordship. Last but one page. Of course, it is IA for suspension of sentence, but lordship has to give consideration. Lordship. Then lordship para 33, bearing in mind the aforesaid principles of law, the endeavor on the part of the court, therefore, should be to see as to whether the case presented by the prosecution and accepted by the trial court can be said to be a case in which ultimately the convict stands for fair chances of acquittal. This is the role of the appellate court, lordship. If the answer to the above said question is to be in the affirmative, as a necessary corollary, we shall have to say that if ultimately the convict appears to be entitled to have an acquittal at the hands of this court, he should not be kept behind the bars for a pretty long time till the conclusion of the appeal, which usually takes very long for decision and disposal. However, while undertaking the exercise to ascertain whether the convict has fair chances of acquittal, what is to be looked into is something palpable. To put it in other words, something which is very apparent or gross on the face of the record, on the basis of which the court can arrive at a prima facie satisfaction that the conviction may not be sustainable. This is the requirement, lordship. Face apparent on the face of record, palpable, what is can be seen. But reappreciation means going to the merits of the lordship, that contradiction, omission, That is not it is apparent on the face of it, Lordship. Because PW1 completely not supported the case of prosecution. PW2, who is the one of the alleged victim, did not support the case of the prosecution. Only on the basis of PW3 can these accused be convicted, Lordship. That too when the IO, MO, and other witnesses were not examined. And when the charge sheet and the FIR is not executed, meaning there by Lordship, these documents have not been proved. When the FIR is not proved before a trial court, charge sheet is not proved. And on what basis, Lordship, the conviction is rendered? This is the finding of the Honorable Supreme Court. When the learned Honorable Appellate Court comes to a finding that the ultimately acquittal may result, then Lordship, keeping them in the custody for a longer period of time, awaiting for the final disposal of the hearing, appeal, is not the Lordship objective, Lordship. Because appeal may take time. Lordship may fix the appeal. It may not reach. Then another again it will be delayed, Lordship. Already these two applicants are behind the bar for Lordship last 404 and 403 days, Lordship. Applicant number 1, Lordship, 404 days. Applicant number 2, 403 days. So, Lordship, it is I'm a humble submission that what I have. It's a palpable and apparent on the face of the record, Lordship. I have only, Lordship, pointed out only deposition of 2 witnesses, Lordship. So, Lordship, in my humble submission, it's a case of Lordship, at least grant of bail, Lordship. Then the appeal may come. Lordship will hear the appeal, Lordship. There is no issue with that.
Yes, Kusami.
Yes, ma'am. What I have
They filed the objection also.
Lordship make only the PW3 minor. What the victim has to say, ma'am. Get the primary facie satisfaction of the court, ma'am. I know the as your Lordship on page 23, ma'am. I know the complainant is Dharmati Tati. I know the accused person Syam Lakwar Paglu, Keshwar Praja, Shekhar, and Pintu Tati, but I do not know the accused Momi Tati. I am the victim of the case. I do not remember the date, month, and year of occurrence, but after the Durga Puja Bhasan, the occurrence took place. One day I was at the house of my relative sister, Gulabi Ghasu. One day, one lady, namely Dharmati Tati, complainant, asked me to go to the house of my aunt Sima, and accordingly I went to the house of my aunt Sima with Dharmati. Thereafter, we returned to the house of Dharmati as asked by. A quarrel took place between Dharmati and her aunt. Thereafter, we went to the house of Kesar Praja, alias Sasensas, and stay in the house with the nights of namely Sandamani in the said night. In the morning, we take breakfast in the house of Kesar Praja, Shekhar. Thereafter, Dharmati took me and Sandamani to her related in-laws house, namely Sham Lakwar. He is the petitioner, my lord.
Yes.
So he is the petitioner, and they all stayed in his house, my lord, after that, my lord. So he is a my lord. He has taken active part in my lord this transporting these girls, my lord, victim girls, my lord. So at this stage, my lord, your lordship, and thereafter your lordship will see, then they were taken to Tezu or Arunachal Pradesh, my lord. I'm not reading the my lord, whole evidence, my lord. Prima facie, my lord, the case has been made out, and that is why, my lord, he has been convicted, my lord, after repair. And what the honorable, my lord, apex court has to say, my lord, what is stated, my lord, my lord, to put in something very gross, and however, while undertaking the exercise to ascertain whether the convict has fair chances of acquittal, what is to be looked into something palpable, to put it otherwise, something which is very apparent or gross on the face of record, on the basis of which court can arrive at prima facie satisfaction the conviction may not be sustained. The appellate court should not reappreciate the evidence at the stage of 389 of CRPC and try to pick up few lacunas or loopholes here or there in case of prosecution. That such would not be a correct approach.
That judgment I have relied.
That is what, and in that case, my lord, the convicts are ordered to surrender before the trial court after they were given bail.
302, something like that.
I have given the printout, my lord.
I have given the copy.
So, my lord, they are strict. So, at the stage of 389 petition, my lord, only your lordship is whether they are prima facie whether the guilt can be made out or not, my lord. Not the appeal. Appeal is a different test, my lord.
But Lordship,
So
this,
bail may
this,
not be allowed if he has any.
this
early hearing
version
or
of,
lordship, I leave it to lordship.
this version of PW3 is not supported by either the informant PW1 or the another alleged victim PW2. PW2 and PW1 did not support this version of PW3, and there is no IO to bring the contradiction, Lordship. The accused has been prejudiced, Lordship. The IO and the other evidence, other witnesses were not called by the Lordship. The IO and the medical officer and the other witnesses were not called by the Lordship learned PP. On the prayer of learned PP, the evidence was closed. That Lordship may can see in the compilation, Lordship. In the
judgment, I think.
that Lordship, I have already Lordship relied. Para 33.
Saying the main part.
Yes, I am saying representation is not Lordship required. But what is palpable, apparent? Yes, I am submitting Lordship. Then Lordship may kindly.
You are insisting on which line?
On page, paragraph 33.
Yes, 33 is also submitting.
Yes,
And
paragraph 33, man.
Para 33.
yes, paragraph 33
Yes,
is
he has
also.
read only half of the portion.
No, no.
Lordship will see, madam. However, while undertaking the exercise to ascertain whether the convict has fair chance of acquittal, what is to be looked into as something palpable, to put in other words, something which is very apparent or gross on the face of record, on the basis of which court can arrive at prima facie satisfaction that conviction may not be sustainable. The appellant court should not reappreciate the evidence at the stage of 389 of CRPC and try to pick up few lacunas or loopholes here or there in the prosecution. Thus would not be a correct approach. On the case in hand, the High Court has done is something impermissible. High Court has gone into issues like political rivalry, delay in FIR, some overratings and other aspects, my lord.
In this case,
Upon-
High Court has gone to
My
the
lord,
aspect of rivalry,
evidence,
delay,
my lord,
etc. Lordship. That is not
coming in for senior counsels. For the same reason, we are unable to approach contention that convicts show their learned counsel meaningless, improper, unjust to keep them in the bar. And accordingly, my lord, they were
asked to surrender.
asked to surrender.
Also, in that case, what happened? Honorable High Court has gone to the aspect of rivalry and delay. That is not permissible, Lordship. But what is permissible is that the learned honorable appellate has to see that whether there is palpable or apparent on the face of record. I am not asking your Lordship to represent the evidence. It is apparent, Lordship. The version of PW3 is not supported by the PW2 and PW1.
Here he put two things which is very palpable on the face of the record itself. One is FIR is not exhibited. Number two, charge sheet is not also exhibited. And number three, at the same time, the IO and MO is also not recorded. What is the reason? Suppose in some time it happens that IO may not be available, he may die, or there may be lots of reasons. But for to contradict or the things, otherwise there are some loopholes. That is the prime facie cases.
Yes.
And
Yes,
Lordship,
anything you want to submit?
also, Lordship, without alternate
No means,
structures.
no means what? Oh, yes, what do I want to submit?
Because I have already deposed before the trial court.
No objection?
No, he has already deposed before trial court as PW1.
Oh, you are the PW1?
Informant.
No objection in vain. Why you are sitting, ma'am?
Then why you are sitting here?
He has already deposed before trial as PW1. Either they are.
But the PW3 is your daughter?
No, no, no.
Who is PW3?
She's one of my cousin.
Cousin? Not cousin.
PW2 is the sister.
PW2 is his sister.
PW1
is, PW3 is?
Someone's daughter.
Someone's daughter.
Someone's daughter.
Someone's daughter?
Yes, he is not examined. That person is not examined.
She is not your daughter.
Who is you are for Jamati? Yes. Jamati Tati Kunal.
Jamati, who is Jamati?
Jamati is the elder sister of the PW2.
She has not been examined.
She is examined. She is PW1.
She is PW1.
She is informant, Lord. She is the informant. And PW3 is the daughter of one Lordship. That is, Lordship will find very. He is not examined. He is also cited as witness. Lordship may kindly see page number 6 of my compilation. Lordship. Page number 6. Page number 6, Lordship, of my compilation, which I have handed over. Lordship. Page 6, Lordship, there is
Because
the
on his informant's FIR, my lord, the case is taken up and the trial has been, my lord, trial has been concluded and conviction
He
taken.
is actually should be prosecuted, in fact. Should be prosecuted.
Lordship,
Because you are, why you are harassing the two, three other persons?
the informant is
If you
deported.
have no case,
He has deported.
why have lost the case FIR?
Lordship may kindly
He
see
cannot
page,
say that, cannot say with the court, my lord.
page number 6, Lordship. This witness number 2, Sanjay Bhumis, is the father of PW3. He is not examined. He is also cited as witness. He is also not examined.
I pray that let the appeal may be finally heard.
And Lordship, one more thing, the without alteration of charge, 370, the applicant number 1 is convicted. He was initially charged with 363. So for major offense, the charge has to be altered, Lordship. This is my humble submission.
Mr. N. Hassan. You, Mr. N. Hassan.
Lordship.
Mr. N. Hassan, the learned counsel for the applicant of the appellant, and also heard Mr. M. B. Goswami, the learned additional PP, appearing on behalf of state respondent. And Mr. You are Mr. S. Sakia, appearing on behalf of the respondent number 2, / informant. This is, we are going to discuss this one. So the letter. This is an application on section 389 CRPC for staying the operation of, for staying of the suspension of operation of impugned judgment and order dated 17/2/2024, passed by learned additional session judge number 2 FTC Tinsukia in session case number 101 (T) of 2023, and suspending the sentence of 10 years in imprisonment and fine of rupees 10,000 in default aside for 6 months passed against the present petitioners under section 370 IPC, and also prayed to allow the applicants to go on regular bail pending the disposal of the connected criminal appeal. Mr. Hassan submitted in this record that both the applicants were convicted under section 370 IPC and sentenced for SI for 10 years along with a fine of rupees 10,000 in default SI for 6 months as referred. But from the charge framed by the charge sheet and the charge framed by the learned additional session judge Tinsukia, it is seen that the charge was framed against the accused applicant number 1. Who is he? Sham
Lakwar, alias Paglu.
Number 1. Now to the Sham Lakwar, alias Paglu. Was he's alive to kill. Number 1 under section 363 IPC, but without any alteration of charge. He is convicted in a higher section, that is on 370 IPC, without even giving any opportunity of hearing in regards to alteration of charge. However, the accused appellant number 2 was charged under section 370 IPC, and accordingly he is convicted under the same section of law. Mr. Hassan further submitted that the entire case is the conviction is based on only the evidence of 3 witnesses, PW1, the informant, and 2 victims of the case, that is the PW2 and PW3. But surprisingly, the PW1 and PW2, the informant and one of the victim of this case, did not support the case of the prosecution. Rather, they stated for the court in their cross evidence that they do not have any objection if the accused appellants are acquitted from this case. The case, the conviction is only based on the evidence of PW3, but the other prosecution witnesses not examined by the, but other prosecution witnesses, including the IU and MO, and one other material witness were not examined by the prosecution, and thus the accused appellant did not get a chance to contradict the evidence of the PWs. Further, Mr. Hassan submitted that the statement of PW3 recorded under section 164 CRPC was exhibited as exhibit 1, but there is the FIR, charge sheet, or any other medical documents, etc., were not exhibited by the prosecution during the trial of this case. Accordingly, he submitted that there is every chances of acquittal in this case, and both the accused petitioners are lying in the detaining in jail hazard. Well, since when?
Since Lordship, applicant number 1, 404 days.
Is the
Total period, Lordship. Applicant number 1, 404 days. Applicant number 2, 403 days.
And so for more than 400 days. Applicant number 1 is in jail hazard since 404. No. Total 404 days, and the other one 403.
403 days.
And the applicant number 2 is in jail hazard for 403 days. So considering all these materials where the prima facie, it appears that where the prima facie loopholes appear before the where there is a prima facie loopholes in the case of the prosecution. This is a fit case wherein both the accused appellant may be released on bail by suspending the sentence imposed on them. Next one. He also relied on the decision of the Honorable Apex Court. Honorable Apex Court, reported by 2023, 6 SCC, page 123. Om Prakash Sahani versus Vijay Sankar Chaudhary and others, and another wherein it has been held by the learned Apex Court, or by the Honorable Apex Court in para 33, that to pull you on 32 to 31. Mr. Sami, the learned additional PP submitted in this regard that the PW3 brought the clear allegation of the allegation against the present applicant number 1 and 2, including one Shikhar, and it is very relevant and it is very evident from her testimony that both the victims were taken to Arunachal Teju, where they were engaged in some labor work. He accordingly submitted that on the basis of the evidence of the PW3, the order of conviction was passed by the learned additional session judge Tinsukia. So and so. He further submitted that at this stage of while dealing with the petition under section 389 CRPC, the court is not supposed to appreciate the evidence of the PWs, which may be appreciated at the time of final hearing of the appeal. Mr. Goswami also relied on the same decision and same para, and he basically emphasized that while undertaking the exercise as to whether the appeal whether the convict has a fair chance of acquittal, comma. It is the court is to look what is something palpable, and it's and it's the and the and the court should not reappreciate the evidence at this stage. Full stop. Accordingly, Mr. Goswami submitted that it is not a fixed case wherein the accused appellant can be released on bail by suspending the sentence, so and so, so and so. Next para. Mr. Piccolo naam to takata. Mr. Saikya, the learned counsel appearing on behalf of the respondent number 2/informant, submitted that he has no objection if these two accused appellant were granted with bail, is released on bail by suspending the sentence imposed on them, as he already stated before the learned trial court below that he has no objection if the accused appellants are acquitted and set at liberty. Next, considering the entire submission made by the learned counsel for both sides, I have perused the case record and the annexures file along with the petition. We service the statement of the witnesses as annexed. Without appreciating the evidence on record, it is palpable from the face of the record that the case is the conviction is based on the evidence of 3 witnesses, out of which 2 witnesses did not support the prosecution case. And in the same time, it is also seen that the most vital documents of the prosecution, that is the FIR and the charge sheet, are not yet exhibited without assigning any reason by the learned session judge, by learned additional session judge. More so, it is admitted fact that the accused applicant number 1 is convicted under section 370 IPC, in spite of the fact that he was charged with section 363 of IPC, full stop. Thus, without giving any opportunity of hearing, the charge was altered at the time of passing the judgment, which is admittedly in the higher sections. In view of above, I find that there are prime facie materials to allow the present petition. To satisfaction of additional session judge.
FTC number 2.
Satisfaction of additional session judge, FTC number 2, till disposal of dissolvent.
And the sentence may can be suspended. Problem. Yes.
Okay.
And the appeal may be fixed in due course, Lordship.
Simple, Lordship, regarding 34 item.
Oh, you have a one item, no? 34.
Lordship, can
Ah. No, I'm not in a position to take.
Lordship, can it tomorrow, Lordship, it's not a hard.
Tomorrow again, it will be again this.
No, in the motion column, it should not have come in the order column, Lordship.
It's an order column only.
No, I have never been hard, Lordship. Wrongly take, Lordship.
Then tomorrow may not be possible.
Lordship, actually,
Tuesday,
it's a regular appeal, Lordship. In 1 year conviction also.
No, okay.
Third, I will not be there.
Third,
Lordship, I will not be there. Kindly tomorrow, Lordship, let's try.
Tomorrow not possible. Not at all possible. That's what I'm saying. Tomorrow not possible.
Third, Lordship.
Third can be.
Second, Lordship, second then. Second.
Third, Mr. Sharma, third, Mr. P. Sharma, the learned counsel 34. So and so. He submitted that the matter should have been listed in the motion column, though it has been listed in the order column. Registry is accordingly directed to list the matter in the motion column. Second, you also. I don't know. Second may not reach.
Lordship, fourth, Lordship.
আহক এলাহাবাদৰ পৰা ঘূৰি আহক।
No, Lordship.
Lordship,
Lordship, it is a fault of the my learned grand council that he failed to do in the on the last day, Lordship. I thought party will hamper.
Okay,
him.
second.
Lordship,
Rest, I'm not sorry, this will appear.
only 40, I need only some documents. I may be allowed to take procure some documents. That
Documents from the record.
How
is it anyway?
Prosecution witnesses.
From the, you have to approach the registry if it allows, because directly we cannot give you to Ferus documents. You can see from the registry itself. Okay.